understandings that we've had with the Corps since basically 2000, and bringing them up to speed, getting them ready for the new Water Resource Development Act that Congress is looking at developing in the future. We also brought up the issue regarding our reclamation project, where we had already gotten funded, and we completed the study on the reuse of water, especially for our area and the dire needs that we have. One of the items that came up in relation to that was discussion with Congressman Filemon Vela and Congressman Cuellar, and Connie also, was the dire need of communication with the Commissioners Court on the dire issue that is developing with the International Boundary and Water Commission on the release of water from Mexico and the status of our community. They apparently, by they I'm referring to our congressional leadership up there representing our area, has submitted several letters already to the Mexican ambassador and also to the State Department, trying to get some action done because of the concerns that they have of our area coming down. He was very explicit in advising or talking to the commissioners that were there that they really needed to get engaged, or the Commissioners Court needed to engage more on a one-to-one with our congressional leadership on the importance of the water for the Rio Grande area, Hidalgo County in particular, which I represent, that it's not just a congressional issue, it's a matter of survival for our community and our growth. And he was very explicit in making sure that the communication that was going on in Congress and with some of the elected officials down in our area, that the whole court itself be exposed to that discussion. One of the items that came out from there, they've got an ultimatum, if you want to say, or some final resolution that Mexico is supposed to give the congressman this week to see if they will release the water or if they're going to have to take it to the next level. And he would like for this Commissioners Court to become engaged in sending a delegation in the next meeting they're having with the State Department, either somebody from the Commissioners Court, from some of the cities, larger cities, those that will be most immediately impacted by the rationing of water coming down to our area. But he wanted to make it a solid point that this court needed to get engaged and needed to communicate with the congressional leadership the concerns that we have down here regarding the irrigation water for the farmers, the water usage for our cities, our major water plants, the economic impact that would have down here if water is not released. It's getting to a critical component on that. So that's
what was the ultimatum? I didn't pick up on it.
Basically, the congressional leadership had sent a letter already to the Mexican ambassador and to the second tier of the State Department that they needed an answer immediately if Mexico was going to release the water. The deadline went by last week, and then they sent another letter giving them another deadline of this week. And if this week was not a positive response, that they were going to follow it up to the Secretary of State, explaining the concern that they have down in our area and the lack of water, the lack of Mexico participating in the release of it. There are also discussions about the global picture, not just of South Texas, but of how the United States is working with Mexico on arms, on other national issues. Our concern is those are great national issues, but we live here in Hidalgo County, and we want to make sure that Hidalgo County's issue is looked at and not fall on the sideline because of other national concerns.
When is the 5-year period up? You know, they got every 5 years they got to make up.
They've got another two years, Commissioner, Judge, that they can hold on.
2 more years?
Yeah. All right. So again, it's a report to y'all. I believe the Commissioner could probably brief y'all more in depth. I know you had Ms. Chapa there also, and I think she took some very good notes. But I believe that this court at least needs to have or consider an item on the agenda for open discussion and to see what position this county will take in assisting the congressman in the future.
Oh yeah, well, put it on the agenda then next time so we can talk about it.
And hopefully we'll get an answer from our congressional lead. We asked them, the commissioners asked them that they would like to have direct communication or advise this court of what comes out of that ultimatum. They also gave the commissioners to give to this court the 2 letters that they've sent already to the State Department and the different entities. Ms. Chapa does have copies of the letter for you, and I believe the other commissioners have them also. But we can present it at the next Tuesday meeting if you wish, Judge.
All right, sir. Any concerns? Go ahead.
Definitely need to improve the communication between whoever gets correspondence from DC regarding this and other matters.
Yes, sir.
That the whole court be a place taking place.
He was very explicit, and again, we were fortunate. What turned out to be a half-hour meeting, we spent almost an hour and a half with the congressman discussing this specific topic that we had there. So it is of great importance and concern for their area, and we tried to explain to them that it also impacts some national issues. If on the 2 power plants or 3 power plants we have down here, if water is rationed and they have trouble on their cooling tanks, what does that power grid impact? It's not just us.
All right, any concerns with the consent agenda?
No concerns, Judge.
Move for approval of the consent.
Those in favor indicate by saying aye. Aye. Aye, motion carries. Item 4.
Item 4, request approval of payment request number 6 from McAllen Construction, Inc. for project number 12-0130410, construction replacement of weir in conjunction with NRSCS grant, main floodwater channel, weir number 2, Williston County Phase 2. The payment request is $130,949.30, signed off by the engineer, subject to being cleared by the auditor.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Item 5, discussion and action on proposed interlocal agreement between Sharyland Independent School District and the Hidalgo County Drainage District Number 1 on the removal of excess spoil from district drainage systems and/or regrading of said systems. Judge, Commissioners, as y'all are aware, the district is moving forward in widening ditches and trying to create more of a linear detention. Unfortunately, in the years past, and by years I'm talking about 15, 20 years when the system started, we would buy right away, we would dig our channels, and we would place a spoil on there. So about 35% of our existing right-of-way is being encumbered by existing dirt that's stockpiled in there. In some of the areas, we own the property fee simple. In some of the areas, we own it only by easement, and thus some of the dirt belongs to the landowners that are there. Sharyland Independent School District at this time is developing a project on Sherry Road, and they're looking for excess dirt or excess material. In moving forward with the district's process of widening our systems, we have some areas that we have some dirt that's there, which can, and it is a benefit of the district to get it removed. Otherwise, whenever we widen our systems, we would have to pay a contractor to move the dirt. So I would like the board's authority, if positive, to enter an interlocal with Sharyland Independent School District where we have the ability for them to remove the spoil that would save us money in the future of widening, and or if there is existing ownership by other people on the ditch and they want to widen these ditches to move the spoil for their site, that'd be allowed to be done.
Godfrey,
Yes, sir.
given the plan that the county has for improvements on the drainage system, it appears that this is going to be the same situation come up time and again.
Yes, sir.
Steve, can we do some preliminary work in clearing this kind of request coming in?
Can I expand on that a minute before Steve responds, sir? Thank you. Harris County Flood Control up in the Houston area, what they do a lot, they get their plans designed, completed as to what the ditch is going to be needing, the right-of-way is bought, and when there are major projects coming out for construction that fill dirt is needed, they put the projects out for bid, and the contractors come and bid to remove the dirt, and thus the facility is dug free of charge instead of putting out a contract to dig the dirt. A lot of transportation contractors go out and buy land to be able to dig dirt for their needs, and thus they look at land that's close to where the project is, and traditionally if you're building a major road project, it's an area that should be economically developed, not a hole dug. So they've been very successful the past 10 years in putting out projects that way, and making it transparent that it's open for bid and out for bid, that any contractor that's bidding on the construction job has the ability to borrow material associated with the site. So it's not something new that we're coming up with or creating. It's something that apparently has been utilized legally and properly in other communities. I'm sorry, I just wanted to interject that.
And I think that would be the best avenue to go forward, because that way the drainage district can actually get money from contractors rather than paying contractors some money to remove the dirt.
Any other questions? All right, I would entertain a motion to proceed
So
to
moved.
that interlocal. Those in favor indicate by saying aye. Aye, motion carries.
Thank you very much, Judge, Commissioner. Item 6, discussion, consideration, and action of verification of proposed uses of and conditions imposed on bond proceeds of Hidalgo County Drainage District Number 1, Unlimited Tax Improvements Bond Series 2013. Mr. Chuy Ramirez asked us to place this item on the agenda, and I believe he's here for the court's presentation.
Good morning, Judge, Commissioners.
Morning, sir.
This verification is procedurally one of the requirements that you have in your resolution where you identified all of the specific drainage projects. And all we're doing is leaving a trail that we're proceeding only with the $84 million project. We're not spending any money on the $100 million for the Raymondville drain projects. And what the resolution provides is a verification.
Can you get closer to that thing?
I'm sorry, I didn't see the mic. I'm sorry. What I was saying, Judge, is that this verification is a procedural requirement under your resolution where you identified all of your projects for the $84 million bond. And so, for the record, we're leaving a trail that we're not touching the $100 million authorization, only the $84 million bond.
Well, we don't have $100 million, do we? I mean, that's what we were trying to get.
Right. What I'm saying, in order to clarify is, we want to make sure that the projects that we have on the $84 million are the projects that we're verifying, that those are the projects we're going to proceed with, and that we can. In other words, they're still all viable.
Okay.
Now, what I'm recommending to your staff in terms of a process is that for accounting purposes, my suggestion would be that you set up some system of identifying each of those projects. I think there's 20 or 21 projects on there that you identify in your records each of those projects, and that as you proceed to award contracts for the design and construction of those projects, that you allocate that authorization to a specific project. You see what I'm saying? So that we can leave that trail for confirmation.
Now, the only question I'm going to have, Mr.
Yes, sir.
Ramirez and Godfrey, is when you look at item number 24 in system acquisition, there's an amount there that the district is going to acquire from the county. From that point, obviously, we're deeding over whatever those assets are. When we get those funding, that money, are we supposed to report where we're allocating those bond dollars to, or does it end at that point?
It is my understanding, Commissioners, that the land acquisition, as we identify each one of those projects, there is going to be an account number set up for our bond release, for our money, saying, okay, we're going to spend $3 million on this project, this account number. And I think what Mr. Ramirez is saying, that way you'll be able to track down exactly where those dollars went to what account it went to, and what specific projects under our bond referendum, which this is land acquisition or resource acquisition, that's identified in there, and that it will not exceed those $10 million that we have under that, on the system acquisitions.
I don't know whether he answered your question fully or not. Let me just add this to that. You're wearing two hats. One is your hat as a district, or a drainage district director, and the other one is as a county court, okay? Under system acquisition, it is the intention of the district to acquire parts of the system that the county has already constructed.
Right.
Segments of the ditch, so to speak. And that's all that's permitted under that section. Segments of that system. As each system, and there's a very comprehensive memorandum that we're drafting on how we're going to accomplish that. Okay. All right? And so, as the money comes as the district purchases the system and pays the county will have a very specific memorandum on how to spend those funds, consistent with state law and consistent with federal law.
Yeah, that's what I'm asking. Because
Yeah.
originally, on some of the funds that we used in the original issuances, in the past, it was a general issuance. At that time, we were doing drainage, we were doing streets, we were doing facilities, and we just want to make sure that once we get the system sold to the district, we understand specifically what we can and cannot do.
That is our intention.
Okay,
Yes.
perfect.
Mr. Ramirez,
Yes, sir.
is there any way you could provide us with a closing statement? We promised Mr. Travers and his group that he expressed a concern as to the closing cost on this bond issue, and I want to make sure that we provide them with a copy of the closing statement.
Of the cost of issuance of the bond?
Yes.
Absolutely.
Yeah.
Why don't, that's going to be done when we close. So why don't we wait until we close on that, and then I'll provide all of you and the staff a copy of that closing statement, and you can see the allocation of those funds.
Thank you, sir.
Thank you.
That's exactly what I meant, Commissioner.
Perfect, thank you.
Do you need action on this?
Yes, sir, I believe so. Ms. Ramirez? We need an action on your item? For approval, yes, sir.
All right.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Judge Commissioners, we had an item under closed session. I've been advised that we'd like to not take any action, table that item.
No
That's
action.
correct.
No action.
No action on.
Need a motion to adjourn?
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you very much, Judge Commissioners.
Amen.
We have about 5 minutes before 9:30 at the start of our regular meeting. To the regular Hidalgo County Commissioners Court meeting for today, March 20th, 2013. Present are Commissioner Cuellar, Precinct 1, Palacios, Precinct 2, Palacios, Precinct 4, and myself. We have a quorum. Please join us in our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Townsend?
Dear Father in heaven, be with us today. Help us as we try to make decisions that are good for everybody in this county. Please guide us and direct us. Bless our families. Bless our country. Bless this county. Please send rain, dear Lord. And help us always to remember to thank you for all your blessings. In the name of the Father, Son, and the Holy Spirit. Amen.
Amen.
All right, our consent agenda, any concerns? Mr. Ofrecio?
Yes, Judge, I have just one item of consent that I would like to pull for discussion, and that's item 2A, as an apple.
I need a motion to approve subject to 2A.
Judge, Commissioners, actually, Mr. Fletcher, you said 2A?
2A, yes, sir.
Okay, well, Judge, Commissioners, I'd like to ask the court, with respect to the consent agenda, we're wishing not to take any action on items under consent 2A, 2B, 3A, and 6A. We're asking for no action on those three.
All right, entertain a motion,
Four.
subject to 2A, 2B, 3A, and 6A.
Move for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. All right, so no action on 2B, 3A, and 6A. On 2A, what's the issue?
2A, they're also requesting no action.
We're requesting no action at this time.
None of those, sir.
All right, then, at this time, in keeping with our policy of deferring to items involving elected officials, we have District Judge Ricardo Rodriguez here on item number 6C, which we'll take up at this time.
Good morning, Judge, Commissioners. I'm actually going to introduce the item, and I have several members here with me. The item reads, requesting approval to apply for funding from the 2013 Justice and Mental Health Collaboration Program, Category 1, Planning. This grant proposal is actually to the Department of Justice, Bureau of Justice Assistance, and what it is going to do is going to be a planning grant, and it's going to provide an opportunity to bring stakeholders together to look at mental health in the criminal justice system. We've been having discussions with the courts. As most of you know, I am actually getting my master's degree in clinical psychology, so this is an issue of great passion and importance to me. And in having discussions with the courts and the justice system, adult probation, and Tropical Texas as well, we thought it was a very opportune time to take a look at this issue, which is trying to serve those who have mental illness, who are coming in and out of the criminal justice system.
What department is going to be applying for the grant?
Adult probation, sir, and we have representatives right here, and there's several representatives. We have District Judge Ricardo Rodriguez with us, we have adult probation, we have Tropical, and at this time I'd like to invite them to the podium to say a few words about this project.
Good morning, Judge.
Judge, good morning. Commissioners, good morning. Thank you for allowing us to be here this morning. As Karina just mentioned, from the court's standpoint, and what we see every day in the courtroom, and we're starting to see every day, is that we have more and more individuals who are coming to the court with mental illness issues. And what's happening is some are picked up at the jails, and a lot of them are not. And across the state, it's becoming more and more of a problem. So with a collaborative organization, including the courts, the county commissioners, the state level, the sheriff's office, if we can come together and with this grant, if it's approved, we can begin the process and trying to figure out how we can streamline these individuals. Because not only is it becoming a problem in the courts, but as we know, many of us have had maybe family members or friends that have had mental illness issues, and we keep putting these individuals in a revolving door, and we're not getting the help that they need. So what's happening is that when they don't get the help that they need, is they're coming back to the jails. They're getting arrested on certain offenses, and or we're just putting them back into the street without the help. And I think what can happen is if we streamline this and we have the collaborative response from all stakeholders in the community, we can try to avoid this. Number one, more importantly, get them help, and two, avoid the expense at the jails as well as keeping them there and getting them some help and getting them somewhere where they don't come back again. For example, there's a mental court in place in Bexar County. What it does, it puts these individuals in this court, just like the drug court that I oversee, and it helps them, for example, stay medicated, make sure that they're not picking up other offenses, and we're avoiding these individuals being brought back into the jail and populating the jail and having more room there for individuals who commit egregious offenses and have to be in jail. So I want to thank Ms. Cardosa for finding this grant and figuring out how, again, we can come together so we can start this process as to the mental illness issue. Okay? So thank you again for giving us that opportunity to be here this morning.
One area of concern that hopefully the grant will address is, what's that section, Rick? Section what?
28.
28. There's a dispute right now or an issue involving who's got the authority or who well, they all have the authority, but the responsibility of executing those Section 28 warrants.
Yes.
You know, the city policemen don't want to do them. They're passing it on to our constables. We're passing them in. There's a dispute in that
Yes.
area, and if that could also be addressed, Judge.
It could possibly be, Judge. For example, the model that's used in Bexar County right now is they have crisis programs where a lot of these individuals, as you're speaking of, are brought into these crisis programs and they're dealt with there. Instead of spending $4,000 on an individual that's going to go through the judicial process, you know, they're spending $350 on each individual to streamline that problem. So the grant itself, if approved and with a study, we're going to find out that there's many things that can be done to streamline this process. Okay?
All right.
And I want to thank the probation department who's here, and also Mr. Cook, also from Tropical. everyone else who's been involved. Judge Bobby Flores, our presiding judge, is also involved with this matter. I've spoken to him, and he's in agreement to make sure that the courts do what they can so we can, again, be together on this issue. Okay?
All right, sir. Thank you, Judge.
Thank you very much. Thank you.
Need a motion?
Move for approval.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Thank you.
Thank you very much.
Okay. All right, I've been requested to move up item number 12J involving our Department of Health. Mr. Olivares?
Go for it.
And of course, we have our mayor-elect from the city of McAllen here with us. Good morning, Mr. Darling.
Good morning, Judge. Thank you. Good morning, Judge, Commissioners.
Morning.
Thank you for moving this item up. We have a couple of things we got to take care of today. We have also, I'd like to introduce the folks that are here, if we like, just to have them on record, if they could come up forward and introduce themselves, Mayor.
Jim Darling with Doctors Hospital Renaissance.
Yes, sir.
Javier Duegas with Mission Regional Medical Center.
Good morning, sir.
Good morning.
Carlos Affirini, consultant to the hospitals.
Good morning.
Judge, also, I'm going to, with your permission, I'd like to see if we could call Mr. Carlos Affirini up and say a few words about the overall scope and vision of these two items involving IGT and 1115 waiver and the direction for the future. I think it's important that you listen to him on a couple of items before we take action on these two items, 1 and 2, if I can, please.
Thank you very much, Judge and Commissioners.
Okay.
I appreciate very much the opportunity to work with all of you and the county auditor in making all these things happen. I think it's been an interesting time over the last 6 months trying to get this regional health partnership put together. Things have come along very well, and Mr. Crane has been a key part of making all things come together. We've submitted the regional health plan in conjunction with Mr. Olivares and his team. We're waiting to hear back from CMS as to whether they will approve the different projects that we pursued. One of the key issues that we've learned now that all the plans have been submitted is that of the 20 regional health partnerships in Texas, the average regional health partnership is accessing about 90% of the money that's available to them. The two Texas-Mexico border regional health partnerships are accessing 45% and 39%, which
Well,
is
that's because our need is a lot greater.
That's right, yes, sir. And so we're looking for innovative ways to finance the waiver so that we can pull some more of those projects and put more into those in demonstration years 3 through 5. We have a couple of ideas to make that happen, and hopefully after the legislative session is over, we'll have more guidance as to whether we can implement some of those strategies, because without those funds, the rest of the availability of those dollars will go to the rest of the state. And so it's really up to us to find some legislative solution to finance the waiver, in addition to what has already been provided by the county commissioners and you, Judge. So with that, I know that there are a couple of issues relating to some of the delayed payments. One of the big issue that we're having is also timing. The state is behind schedule by about 9 months. They haven't even made payments for 2012. They have not closed out their year for 2012. So if you think about it, we're in March, 7 months after the end of the fiscal year, the state fiscal year, and they still haven't even asked for the intergovernmental transfer. I think that the timeline of the intergovernmental transfers and the supplemental payments is going to get a little more standardized probably in August of this year. But with that, we need to make sure that we find a way to address the budget issues so that the hospitals are able to access the supplemental payments and that the availability of those funds doesn't go to other parts of the state. So if you all have any other questions, I'm happy to.
All right, so the issue here is on item 12J1, we haven't paid the 2011 year.
Yes,
Now,
sir.
how much do we still owe the fund?
Let me move on to item J1, sir. In 2011, the county appropriated in their budgetary action $8.5 million to be used for indigent health care services under uncompensated care, part of the 1115 waiver. The county actually paid out at a level of $6,374,999, which left a surplus of $2,125,000.33.
125?
$2,125,000.
Okay.
2.125 million. 2.125 million. And what happens, sir, at this point, what we're seeking is a mechanism or a method to see that money, if it could be.
You're seeking a check from the
That's
county
right.
for
Now,
$2,125,000.
the hospitals are requesting
All right,
that
why
money.
have we not paid it?
Sir, because what happened is, in the process, there were some scheduling issues with the state and how the multiplier worked. The funding available to multiply the money had run out, but only because the multiplier wasn't there doesn't mean that this money could not have been used for indigent healthcare services. In fact, services were paid for by hospitals and doctors and pharmacists, and relying on that money, sir. And so now the hospital group, pharmacy group, physicians groups are all coming back and asking to see if we could contribute that money back into it, put that money back into it.
What's standing in the way? What's holding it up, to your knowledge?
Procedural items are in the way, sir. The auditors made it very clear that we cannot go back to 2011 and use money from that period. The mechanisms are in place that prohibit that action taking place. Am I correct, Mr. Fracio, on that?
Mr. Ofracio, if we owe the money, why can we, and we have it in our fund, why can we not pay it?
Judge, this is a complex issue, but let me see if I can explain it in simple terms. The county has
Hopefully you can.
The county has a policy that any funds that you don't spend in a particular fiscal year on that budget roll into fund balance. You cannot tap into those funds because the year is already over and we get a new budget. So for 2011, the hospitals were able to I guess they leveraged funds, but there was an issue with the cap. They couldn't leverage any more funding. That's why they were not able to utilize the $8.5 million that was available.
But we owed them the money. The state obligates us to pay 8% of our budget, which would have meant about 12 or 13 million, and we were able to work out an agreement for 8.5 million that I feel we need to honor. Why should we not honor that agreement?
Well, because of that, like I said, the county has a policy that whatever funds you don't spend for a particular budget year, they lapse it to fund balance. And as you know, every year the county is short on funds, so they use fund balance to balance their budget. So in 2011, whatever funds were not spent, not just for the 1115 waiver or for the UPL, from any county departments, rolled into fund balance, and then from there you balance your 2012
But
fiscal year.
they're saying that they were prudent in not requesting it because they were waiting for some procedural change to occur with the state.
There was no procedural change. Again, the issue was that they reached a cap. The state can only leverage up to a certain dollar amount. They reached that limit. What was happening in 2011, the multiplier went up, increased. So the hospitals asked for like a $4 million transfer of monies in order to take advantage of the multiplier, which the county did. The county gave them $4 million, but the problem is they reached a cap and they couldn't leverage any more funds.
Judge,
So we couldn't transfer any more funds. That was what happened in 2011.
Judge, and what Mr. Fernandez is saying about the cap is accurate, but however, what happens is that the commitment to use that money could have still been used unmultiplied to provide services directly to the indigent in our community.
So what were they doing with the hospitals, allowing it to sit there until the next year came in?
No,
They
sir.
could use it to double up or whatever the...
No, sir, they were asking for that money. And the thing is that the state came in this whole process and had capped that, but the cap did not mean that you could not apply whatever money you had committed to be used for indigent care services. And that's the primary issue here at hand. The hospitals are saying, we, not only hospitals, but the doctors and pharmacists also, we all participated in providing indigent care services. We were expecting the 8.5 million from the county as indicated, and we were given a little over 6 million, therefore there's a 2.125 million that is owed to us. I think Sergio wanted to say something else.
Judge, so bottom line, those funds are no longer in your budget. What you have in the budget right now is $8 million for 2013 that is available to be provided to the hospitals so they can leverage it. But 11 and 12 is gone.
Let me ask a question.
Sure.
How do we handle other budgetary items? Do we handle them as claims?
No, like I was saying earlier, whatever you don't pay that is in your budget and the general fund, it lapses into fund balance and it's gone.
Well, time and time again, we have requests from different departments.
Right.
They come in and present some claims against
Yeah,
the,
but in this case, it's not a claim per se because,
well, the service is being provided.
yeah, but
That's
the
right.
the other issue you got to
You're right.
understand is that we got
Yeah, they provided this.
federal regulation, Judge. That's the other issue that I want to bring up. You need to comply with those federal regulations. The last time the county didn't comply with those was assessed a $10 million penalty. So it's real important that we comply with those regulations. But
What about the regulation that requires that we pay up to $30,000 per individual?
No, what the regulations say is that there's not supposed to be a quid pro quo. The hospitals were responsible to take over the indigent healthcare expenses, and the county was responsible to invest up to a certain dollar amount into of IGT. And that's what the county has done. However, for those 2 years, the hospital had not been able to utilize the entire amount of IGT. If they don't use it, it's gone. So you don't have those funds available. You have this year $8 million to leverage, and it's there, but they have not been able to tap into it.
Judge, the issue here also is that the money that was allocated was assigned to help the poor in this community.
What's what?
The money was assigned to help the poor of this community, to help the indigent services in this
Well,
community.
it was to cut our obligation. The state mandates that we pay 8% of our budget, which would be about 12 or 13 million in 2011.
Correct.
Because of this program, we were able to cut that down to 8.5.
Correct.
And legally, Steve, are we obligated to pay it?
I think you were obligated to pay it in the year that was due. Now, I think we have some issues of how we can make it right. We're probably going to take a budget amendment for this year, and then apply those funds to IGT for this year, so that this year they can be multiplied. Correct, Eddie?
Right. One of the things that, and Sergio and I were reviewing this also from the budget office, that there's a possible solution where there could be a budget amendment for this year where the money, that 2.1 million, could be added to this year's budget area, and that could be used, it could actually even get multiplied, and there could actually be more benefit from it if it's added this year as part of the mechanism for this year. So that way it would compensate the hospitals, but there also would be an opportunity to multiply it as well. Because as of right now, there's more than enough money to be multiplied at the state and federal level. I mean, exceedingly amount available. So it could be a win-win situation if this is the direction the court wants to go for 2011.
Judge, but the only way you can do that is to declare an emergency, because again, the monies are in your fund balance.
It's
And
either an emergency.
you cannot
Excuse me,
access
Mr.
fund balance
Frascio.
until,
Excuse me, it's either an emergency or unforeseen situation.
right, that's what I'm saying. You have to declare an emergency, you have
Or
an
an unforeseen situation.
I'm sorry?
It's emergency or
Right,
unforeseen
no, that's what I'm
situation.
saying. Yeah, the county has to declare an emergency in order to tap into.
No, they have to
fund
declare
balance.
either an emergency or an unforeseen situation.
What would the unforeseen situation be?
The unforeseen situation would be that IGT has now come into effect, and that you had budgeted items in the past to indigent health care under the UPL program that, for whatever reason, had not been spent, and that would be the unforeseen situation.
I'm not sure if I consider that unforeseen, but it's a legal question, Judge, and I'm not authorized to issue legal opinions, but that's something that has to be looked at by legal.
Judge, may I address the unforeseen circumstance?
Yes.
The way that the state determines the availability of the funding is that they wait until the fourth quarter of the state fiscal year, and they say, this is how much money has been accessed by the rest of the state. So if Houston or Dallas overfunds, and they're putting up hundreds of millions of dollars, then they will apply the haircut across the state. So we're not able to know what the actual fourth quarter will look like until probably 2 weeks before the end of the year. So going into that particular circumstance for the quarter 4 2011 funding cycle, it was unknown until, and I wasn't representing the hospitals at the time, but it was probably unknown until mid-December. And then the state probably refunded the money to the county because they said, we've taken on too much money for the state. There's no way to know that. There's no way to know that going into this year. And so what we're trying to do is find a way to address that issue on the front side for 2013 and 2014, and 2015 for that matter. But in the 2011-2012 cycle, there was absolutely no way that any hospital, or any lawyer, or any consultant could have known that that haircut was going to come into place and what level the haircut would actually come in.
That's your unforeseen circumstance?
Yes, sir.
So we just got to find out if it's legal or not to...
Judge, can I address an issue that this is not a windfall for the hospital. This money goes to the state to come back to the hospitals in the form of payment for uncompensated care. So there's no, we have a pretty good cap, unlimited cap on that because all the hospitals contribute to uncompensated care. So this money is not coming back. It would be used actually for this fiscal year for the hospitals to cover uncompensated care. And there's not an $8 million cap on that by any stretch of the imagination. So I think that's important for the Commissioners Court to understand what the ultimate use of this money is through the 115 waiver program. That's kind of carried forward the UPL program as it relates to uncompensated care.
And does the money also, I guess, provide the payment for health care to indigents that are being provided by doctors and nurses?
Right. Whatever left over after indigent care goes to the hospitals to pay for uncompensated care that's not covered in the indigent care program. So we funded more than $8 million each year in indigent care, meeting our moral obligation to the county to do that. And we've continued that even though we haven't received the county share in 11 and in 12. And we, at least as far as I know, continue to do that. But at the same token, uncompensated care doesn't reduce itself either. I'd like to point out one other thing about the 115 waiver program. When we talked about only funding at 38%, it really is not, we have a lot of need, but the 38% problem is because there is no IGT transfers out there, because the county doesn't have a county hospital like the other 7 large metropolitan areas in the state of Texas. So the UPL is really hindered by the fact that the county is very limited in what it can contribute to IGT, so are school districts and cities, et cetera. And that's coming up with something to be able to draw down our fair share of that money for Hidalgo County citizens has been difficult because we don't have the IGT opportunities other large urban areas have.
Right. Well, I see it as real clear. We obligated ourselves to pay $8.5 million into this fund. We need to honor that commitment. And again, as Commissioner Cuellar said, if it's legal, and I believe from what I'm hearing from Mr. Crane, it is legal so long as the issue of unforeseen circumstances is met. And I can understand the facts as have been stated to us that there were some unforeseen circumstances. I'm not sure what other questions anyone here may have.
Well, that's the only issue that I had, Judge. The other question, the only comment that I would like to make, Judge, is that we got to make sure we have a plan in place for the 1115 waiver, how the monies are going to be allocated and transferred. We don't have one at this point. And last time when the item came up for discussion, that was one of the recommendations we had. We got to have some kind of policies and procedures on how the monies are going to be transferred and allocated, because now we have uncompensated care and performance improvement projects. Some hospitals are not involved in the uncompensated care portion of it. They're only involved in the performance improvement project.
All our hospitals are involved in uncompensated care. Some are not involved in disproportionate share. The reality is, sir, is that the state is going to be in charge of outlining those directions and guidelines. We could develop some localized policies and procedures for Hidalgo County specifically that we could look at. In fact, I'm going to even discuss some of that in the next item, where we could actually develop those procedures internally within our county to be able to plan out for the rest of 2012, the state year 2012, 2013, and into 2014. But that will be the next item, but definitely, I agree, there needs to be a procedure set, and the procedures we've come up with are very basic and very simple. But again, we have the state guidelines to follow as well, which will be determined by the state and the federal government, sir.
So is the court ready to take action on J1? Are there any other questions, members of the board?
Judge, really, there's no action on J1 today. It's more of a procedure of how we're going to go forward. We'd have to have an amendment on the agenda to do that.
I just want to clarify, Judge, my understanding is that we will have to be bringing back a budget amendment to the court for the court's approval, and also, I guess we would have to have a statement determining what the unforeseen circumstance was, get that approved as well, and then we would be able to amend this fiscal year's budget. We would not be amending the prior fiscal years where the payment was not made, but rather we'd be amending the 2013 fiscal year budget to increase the contribution to the 1115 waiver program from $8 million to whatever the amount that was deficient on the prior fiscal years. So we'll bring that back as a future action item for the court.
All right, what about J2 then? Let's proceed. We've got to move on.
I'd like to just go back to J1. Just for the record, sir, just for clarity.
Eddie, I think the consensus is you're going to get it.
No, sir. It was just, thank you, sir. It was just actions giving direction to Sergio and myself to come up with that. That was all. That's all I was asking about.
Judge, but just for the record, I will not be able to approve the payment until I get a legal opinion. That's
Okay, well, Steve, can you provide that legal opinion?
I'm talking about
If he'll accept
a
it.
formal opinion, not a verbal opinion.
Mr. Crane says he'll provide that legal
All right,
opinion.
great.
All right. Let's move on to J2.
On J2, sir, J2 is a similar situation involving our discussion and action and pending IGT transfer for Hidalgo County fiscal year 2012 as per attachment documents prepared by County Auditor's Office. Sir, on this one, what I want to do is, there are funds currently in accounts payable, account number 2-1100-200-000-017-000, just for the record. I'd like to ask the court to make sure those funds remain in that account and to be used for the first quarter payment, which consists of September, October, November of 2012, in the amount of $2,062,500, and to be used for the second quarter of 2012, which second quarter, which consists of December 2012, for an amount of $687,500, and those funds remain in that fund balance in that account to be used to pay for 2012 1115 waiver indigent care program.
Those funds are no longer in there. Again, those funds had lapsed into fund balance.
Well, it's
Can
the
you
same
repeat that, sir?
argument.
Can you repeat that, please?
It's the same argument. That
It's the
last
same
we
argument,
didn't use
Eddie,
them.
so those funds had lapsed already. Like I said
Okay.
earlier. I'm telling you, I keep the ledger, so I'm telling you what's in there and what's not in there.
Okay, so they're not there.
They're not there anymore. They lapsed into fund balance.
Okay.
All right, now how much, we obligated ourselves to pay 8.25 now for this particular year. Not
Yes, we
8.5.
obligate ourselves 8.25 million this year.
8,250,000.
Correct.
All right, how much have we paid?
Zero.
What do you mean zero?
That's not correct. In
No.
2012.
No, for 2012.
Oh,
how much
and
did we
13 is
pay?
$8 million. In 2013 is $8 million whole. We have not paid any because they have not asked for a reimbursement.
Because the reimbursement schedule, we're still working on with the state, sir.
Let's not get into 13, let's talk about 12. We obligated ourselves for 8,250,000.
Correct.
Right.
How much have we paid on that amount?
I think there's a balance of $2 million.
We've paid 8 months of that requirement. We still have September through December of payments that are.
Is that 2,062,500?
Is that the number you gave, Eric?
Yes, for December, September, October, November, 2,062,500, correct.
All right, and those monies have, I guess, what do they call it, lapsed into the general fund?
Fund
They
balance.
will have lapsed, yes.
Fund balance, yeah.
Fund balance,
There's
but that's the money
2.75.
that we had obligated ourselves to pay, and we need to honor that obligation if it's legal again.
Yes, sir. And I think this is something that I guess we would have to put as a fiscal note on our CAFR for this next fiscal year, Mr. Ofracio? Is that correct?
Yeah.
So we would document that, the 2.125 from 2011 and the 2.75 from 2012 as being due and payable to the UPL 1115
It's not
waiver program.
75, it's 62.5.
Yes, 2.75 for 2012.
Oh,
Should be
so
the-
it is 2,075,000?
2.75 for 2012 and
Okay.
2.125 for 2011, correct.
So we do have that application.
Well, I don't know if you want to call it an obligation. The county.
What can we call it? Then
The
we
county
call it-
the county decided to invest up to a certain dollar
Yeah, it's
amount.
an obligation. I mean, we're legally obligated, we told them we would do it, we're saving about 4.5 million.
Find a way to do it.
Yeah, the key to look, the way to look at this is we're saving close to $5 million in that particular year that we did not have to fund, that we are required by state law to fund. Through this program, we're saving those dollars.
No, I understand how that works, Judge.
Yes, but
I've been studying this for a while.
You may understand, but we make commitments, we got to honor them.
It's up to you all to decide. So if you want to decide that, like I said, all I got to have is a legal opinion that you're going to declare an emergency for an unforeseen circumstance because that's required in order for you to
Not
get
an
the fund balance.
emergency.
That's all.
That's an unforeseen.
So Eddie, would you follow the same process, being the fact that the funds are in the fund balance now, as we are going to follow in J1?
Right. My thing is, I'm trying to avoid a J1 situation in J2 year, so we're pre-planning to avoid a problem like that under this year. So we're trying to pre-plan as much as we can to make sure that the payments are made in a timely manner in accordance to state guidelines, which they haven't given us to us yet, the dates, but we got to pre-plan because I'm scared that if we don't continue to plan for this year, we're going to be in the same situation next year.
Right.
Why
and
why
I
don't
agree
you
with
then prepare some facts, a memo laying out the facts to Mr. Crane so that he can
Mr.
then
Crane has that
rely and tell
information
us
already.
about unforeseen circumstances?
Mr. Crane, he has all that information already.
Well, do it in a one-page memo.
Include the auditor.
Give me a one-page memo.
Yeah,
Now,
I'll do that.
Eddie, Judge, I want to make
I'm
sure
sorry,
that,
Commissioner,
for the
I thought
record,
you were through.
it is clear that these funds are going to be for IGT purposes. We're not going to be able to pay these monies to the hospitals directly.
I don't think that's the decision I think that's a decision the court needs to make. If the court, Mr. Frasso, if the court commits $8.25 million to be used for indigent care services, that's indigent care services, period, be it IGT, no IGT, et cetera. It's indigent care services.
Like I said earlier, Eddie, last time the county did not comply with the federal regulations, they got hit with a $10 million penalty. And I'm not about to allow the county to get into a situation like that again.
Mr. Fracio, I'm sure that all our actions will be reviewed by legal counsel and by everyone on that. I would suggest and recommend the court, any action that we taken will be reviewed by legal counsel, and that determination will be made by legal counsel and someone who maybe specialized in that area or understands the law and techniques.
That's why I'm asking you to lay out what you believe these unforeseen circumstances
sir.
are. He can rely on them, he can give us a memo, and then we can vote.
I will.
And be clear on that memo, how you're going to use those funds. If they're going to be IGT or non-IGT, because if they're not, I'm going to have to ask CMS again whether they're compliant with the regulations. And if it's not, we're going to be in the same boat again. That's why.
Yes, sir. We'll do that.
It would be wrong for us not to pay it, and especially if we're somehow later on not qualified for this program, and then the county's going to be stuck with having to pay by then it'll be about 13 million.
Or more, sir.
Or more, yes.
In fact, sir, one of the things that a lot of people don't understand is that if things don't work out, even according to reviewing Mr. Crane, some state statutes and state laws are very clear that say that all the cards fall in the wrong direction and things don't work out, the county has a due diligence and responsibility by state law to pay up to $30,000 per person who qualifies for indigent healthcare services, and we have that liability.
Right. We understand that.
And that could add up to hundreds of millions.
Well, that's the way we used to do it before this program came into play, this
Right.
UPL deal.
So, okay, sir, I'll get that document to Mr. Crane, we'll work with it and follow through on that.
All right. Thank you, Mr. Oliva. Thank you, gentlemen.
So,
No
Yeah, there was no
action
action needed, just a
until they
guide
get
or
the memo out there.
direction.
All right. Let's see, Mr. Paul Villarreal, our elected tax assessor and collector, is here to present on item 11A.
Good morning, Judge, Commissioners. It's good to be here before you. On item 11A, respectfully, I'd like to ask you for approval to transfer idle allowance in the amount of $1,500 from slot number 28 to slot number 41. There's no budget impact. What we're doing is, the person that was doing is no longer doing it, so the employee that's going to get the allowance is going to be traveling to Human Resources and to our 5 stations that we have we have the one in West Lago, the one in FAR, the one in San Juan, the one in Alamo and in Palmview, so that's what we're doing, just transferring.
Move for approval of 11A, 1 and 2.
All right, those in favor indicate by saying aye. Aye. Aye, motion carries. Thank you, sir.
Thank you, have a good day.
Thank you. Oh, yes. I believe, yes, we need
Just the approval of the revised salary schedule.
The what?
It needs an approval.
we did it.
Oh, great. Thank you very much.
Thank you.
All right, let's now go back to our regular agenda item under open forum, Lydia Jeffries. Ms. Jeffries?
Good morning, Judge, Commissioners.
morning.
Good morning.
Today I came to ask
Valde,
you
súbele un poquito.
some resolutions in action for the project done to my mobile home. We have on top of us the weather so hot and right now is too hot. We have two air condition units, 2 air conditions, in fan in another fans, and it's too hot. And nobody can give me any information. I don't know what to do or who is responsible for the damages have done on the mobile home. I really can do nothing without the information.
Yes, ma'am.
So I ask you or somebody to give me information or some kind of documents that I can do something. I don't know anything, what was the project or what was they have done without telling me nothing. So I ignore everything. I can talk with Commissioner Flores. I talked with Mingo and Jaime. They went to my mobile home to see the damages, and I don't have any response.
All All right.
Please help me to get some responses. Thank you.
Okay. Thank you, ma'am. Next presenter is Opal Billman.
Good morning. My name is Opal Billman. When Joe Billman petitioned the 275th District Court for a divorce, he owned an undivided 1/2 of 72 acres with capital improvements. He still does. The judge's appointment of a manager and a beneficiary for our community property does not qualify as a divorce settlement. It constitutes grand larceny. The most notable feedback of my remarks to this board have been, no one is going to do anything about it. Nobody is listening to you. We, the people, elect representatives to go to Washington, D.C. and make laws all the time. Why? We have local district judges. How about if we all just use district judge law? The district judge can tangle our property up in his court and just keep it. Joe died. The district judge does not acknowledge law that tells him he must dismiss the case. The district judge has our property tangled in his court, and he's going to just keep it. He's not about to release that windfall. Barratry is maintaining groundless judicial proceedings, and in this case, for 15 years and still going, which includes false imprisonment and 2 unconstitutional jury trials. Yet I am told nobody's going to do anything about it. Nobody is listening to you. We have district judge law. Because this has been a really long-term divorce action, in May, when I went through a 3-day second jury trial, which resolved nothing, since the court still has our community property tied up, and I'm still being held in police-enforced false imprisonment, I filed another complaint with the Attorney General of the state of Texas. His form letter advised me to get my own lawyer. Since I've already made the rounds of McAllen lawyers, this past week I called 7 lawyers in the Corpus Christi area. I was sued for divorce twice, 6 years after Joe's death, and again 9 years after Joe's death. The state of Texas has had me arrested, jailed, and tried for criminal trespass. The criminal trespass being that I was standing on land that I own, which is easy enough to know. Call the tax office. The taxes are still being paid by the estate of Joe Billman and me. I would like to sue the state of Texas to stop the false imprisonment, my confinement, and for giving me my now criminal record. There is just no lawyer that wants to. After all, nobody has to pay any attention to existing laws. We have district judge law. If the district judge can just use his position of power to walk off with a chunk of valuable real estate for free.
You have 30 seconds, ma'am.
People who stand to profit are absolutely not going to do anything about it. They want what we own, and the district judge is getting it for them. Our government is we the people. Is this what everybody really wants? What happens to our Constitution and existing state law? Who needs representatives in Washington, D.C. to pass more laws that nobody is going to do anything about? When Joe died, if the 275th District Court had obeyed the law and dismissed this divorce case and the unconstitutional court orders, that this court action would have been depleted 10 years ago. There is nothing to be overturned. the case would have automatically reverted to existing constitutional and state law. All that is needed is compliance to existing law, which requires the district judge to dismiss the case. Because it is the law, I want the judge to dismiss the case and free me. I want my freedom, I want my liberty, and thank you very much for your time.
Next presenter is Virginia Townsend.
Yes, good morning.
Good morning, ma'am.
I'm going to, I know y'all can't answer me back, but anyhow, I have to complain about 9D2, where someone is getting a $13,160 increase in the position. So I'm not going to say it's a person, it's the position. But how in the world can a clerk 3 get a $13,160 increase? It doesn't look right. It's the reason.
What item are you talking about?
I'm talking about 9D2.
Okay.
It's the reason that we like step and grade like we do. We keep saying something has got to be there as a guide so everybody stays where it makes sense. If you get out of something making sense, then you start trouble among, every other clerk 3 in the county must go, oh my goodness. It's not right, and I don't like to complain because it's happening somewhere very close to my heart, Precinct 3. Nevertheless.
All right.
And may I say, while I'm talking about Precinct 3, the Commissioner Joe Flores is one of the most kind, generous people I've ever seen in my life, and he helps people all the time. And the county also is very helpful towards people who need help. So usually it works out very well, I guess. Anyhow, I get a little offended when somebody says they don't do anything, but whatever. Also 23A6. I thought we had already paid for a schematic design for the courthouse. We've already paid a lot of money, had a lot of work done. I don't know what it was, but I can look it up because I did keep records. But I thought we had already done a schematic design. I don't know.
No, we have not, but we'll talk about it when we get to that item, and you're welcome to get up and say whatever you want to say.
Thank you.
Next presenter is Frank Travers.
Good morning, Judge, Commissioners.
Morning, sir.
While there's an agenda item that brought my attention today, I'm not speaking on it at all. It's on the revision of the Department of Energy grant, which is coming to a conclusion. The commuter rail falls underneath that grant as one of the projects. However, I've been assured that it has nothing to do with this particular agenda item, or the closing of the grant is irrespective, does not affect commuter in any way. But I would like to address that a little bit. As you know, I was working hard on the feasibility or lack of it of the passenger rail system here, and we were getting close to the end of it, and I was asked to hold off for 6 months for the good of the county because it was part of the overall energy grant, and it would be perhaps awkward if we tried to close the commuter rail prematurely even before that finish. So I responded to that certainly if I didn't quite understand why the delay was really pertinent, but that if it could be explained to me and I could participate, I'd be glad to help, still work on the total grant closing. That meant I had a lot of work to do to catch up with a whole new subject. So I started to look at the entire grant of about around $3.5 million. And when I look at something like that, instead of putting pieces of paper that are pertinent in a file, I get out a big red grinder and start to index them, put them together, and it's like a jigsaw puzzle. After you look at them for a while, you begin to see the picture. I discovered a little bit more about how the projects were reported and made available to the public through government websites, and there's particularly two of them. One is a quarterly basis which reports project by project their total program to date expenditures and information, and the other is a summary from the government year by year of how much has been expended and is left. I've got into both of those and have reconciled them, and the part I'm concerned with is the quarterly reports year to date, which are a narrative section, not the money, but a verbal status of where we stand. And this is what our report says on the computer rail feasibility study, and this is reading verbatim, word for word, out of the December quarterly report that went in and is now reported to the worldwide as to our status. Commuter rail feasibility study, : the feasibility study has been completed and a rail system is feasible in Hidalgo County. Study was accepted by Hidalgo County and Commuter Rail District. Study is being shared with other entities for discussion, recommendation, and next steps to continue the project. Contract has been awarded Lockwood, Andrews, and Newman. Period. That's the end of the section on commuter rail. I don't think that's a very realistic presentation. I know of only discovered 3 or 4 people in the entire county that really are pushing rail and wanted to go somewhere. Even to the man on the street with very
You've
little...
got about 30 seconds, Mr. Travers.
Very little knowledge seems to think it's ridiculous. Somehow I wish that integrity before the court and information that you're given could be kept credible and accurate. I know things have been said which you already have in your hands, information that shows that it cannot be true. There are no profitable rail systems in the United States, even though you have told otherwise that there are a few. The facts do not support that, and I think it would be beneficial if we could somehow edit things down so that only truthful, honest information was given to you. Thank you very much.
All right, next presenter is Oscar Montoya.
Morning, Judge, Commissioners. I apologize, there was a misunderstanding and I wasn't able to get on the agenda today, so I signed up for open forum on the water update.
Why don't you just prepare an agenda item so that we can talk about it next week?
Okay,
Nothing's going to happen between now and then, and you'll be better prepared, and so will we. That way we can ask you questions.
Okay, no problem, sir.
All right?
No problem, thank you.
All right, sir. Next item, item 6. 6A, bills before the legislature. Is there anything pressing that we need to know about? We're running behind, that's why I'm trying to move it.
Judge, there's nothing pressing right now, other than, the Mexico bills, House Bill 24, Senate Bill 24 and House Bill 1000, relating to the creation of the new University of South Texas within the university system. As everybody knows, it was passed by both the Senate and the House, so it's moving forward. Other than that, Judge, that's all I got.
All right, thank you, sir.
What about Senate Bill 1426?
Senate Bill 1426, Commissioner, is a bill by Hinojosa, is relating to the appointment of the county auditor. My understanding from the last action that it was sent to the Intergovernmental Relations Committee, so it's still in committee.
Judge, well, do you have any, I would appreciate it if you can give us some...
Judge, I would like to ask the court and see if they could...
some feedback on that as to the status or include it on the list of...
Call the author of the bill or his staff and let them give you an update.
Yes, sir, I will.
Mr. Ofracio, you said something?
Well, what I was going to say, I was hoping that this Commissioners Court can submit a letter stating their opposition to this bill. This bill, in my opinion, is going to remove the independence of the county auditor's office. Therefore, I'm not going to be able to perform my job the way that I've been doing it for the last 8 years. So I don't think this is a good piece of legislation, Judge, in my opinion.
Well, I don't think we know enough about it, but why don't you put it on the agenda as not just a report, but a actual discussion item?
Based on the fact that
I will.
That now the Commissioners Court could select the county auditor instead of the district judges.
I don't think that's the case.
I'm sorry?
I'm sorry. My understanding is not that. The court is not going to make the selection appointment.
Well, it'd be a county auditor board, which would be comprised of 2 members of the Commissioners Court, which includes the county judge, and 3 district judges. So possibly, you could have a majority where the Commissioners Court could dictate who's going to be the next auditor, or if they don't like the auditor that is in place, remove it.
Or the district judges.
Well, yeah.
The way I understand it, there will still be 3, the majority will be district court judges, and they're trying to get people on the board of judges that will make the ultimate decision, that will be able to provide some circumstances, some facts, some examples of what's going on at the county commissioners courts throughout the state. This has got nothing to do with Hidalgo County.
Well, the fact that it was entered by senator from Hidalgo County, I would think it has to do with Hidalgo County, but I don't know. That's just my impression. But in my opinion, from my standpoint, Judge, I'm the county auditor, and I don't think this is a good piece of legislation for county auditors.
Well, it's not an Hidalgo County bill, it's a state of Texas bill, and if the law changes, it will apply all over the state, not just in this county.
Correct.
Okay. Well, put it down so it gets, come up to speed on it.
Yes, sir, I can bring analyze the bill and bring it before Commissioners Court next week.
All right, sir.
Item 6B, Judge, I was informed that there's no action on that.
All right, item 6D is in David. No, the next item. The next item is 6D is in David.
Yes.
Right.
Morning, Judge, Commissioners.
Morning, sir.
Michael Leo, County Judge's Office. 6D, authorization to submit the historic Hidalgo County Courthouse Plan to the Texas Historical Commission for review, comment, and approval. In September 2011, Commissioners Court established the Courthouse Master Planning Committee with recommendations from the members coming from the key stakeholders, county offices, including the judge and the commissioners, as well as representatives from the community at large. The court also commissioned the preparation of a Hidalgo County Courthouse Master Plan, which included an assessment of the existing courthouse, the needs of all stakeholders, as well as presenting final recommendations to the court. This past November, the final deliverable of the Hidalgo County Courthouse Master Plan was approved by the court. One of the components to this plan is the historic Hidalgo County Courthouse Plan. In searching for funding in 2011, our office established communication with the Texas Historical Commission regarding potential grant funding. Judge Garcia met with Sharon Fleming, who is now the director of the Texas Historical Courthouse Preservation Program, along with representatives from the city of Edinburgh. We were advised that the county was eligible to request grant funding for cost of renovation for the existing courthouse. This plan, the historic Hidalgo County Courthouse Plan, is a prerequisite for any consideration of grant funds. The county is not submitting the grant application at this time. However, we are asking the court for approval to submit the plan to the Historical Commission for review, comment, and approval.
Second.
Raul, Chilguero, do we have a copy of that?
I believe a copies were provided to the courts and to the chief administrators, but Mr. Silguero, yes, the historic plan?
Didn't I get provided, Commissioner? I haven't seen it.
It was together with, there was a Hidalgo County Courthouse Master Plan, and then there was the historic Hidalgo County Courthouse, which was a separate.
We have it in the office, Commissioner. We have it in the office.
If not, we can request additional copies and submit, and
Make sure that,
send it to the court.
All right, we have a motion and a second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
Thank you, sir. Item 7.
Thank you, Judge, Commissioners. There's no action on items 7A, 1 and 2 at this time. I'm going to skip 7B for a couple seconds. Item 7C, under the A&M AgriLife Extension Service, we do have a request for Ms. Barbara Storrs to travel to Washington, and this is on a review for Community Foods Review Group of National Institute of Food and Agricultural Food Safety Nutrition Seminar. There is no cost to the county. It's just a disclosure on our part that Barbara would be attending attending the seminar and the travel to Washington.
Move for approval.
Judge, I just want to state for the record, this individual is going to travel to Washington DC. She's not a county employee, however, county supplements the salary of this individual. This individual is going to apparently make a presentation in Washington and receive payment for doing that. There's no policy that I can see in the county for how to treat those instances. We got an opinion from Assistant District Attorney indicating that the employee is not a county employee, there's no county funds involved, therefore, everything's in order.
Josie, are you going to say something?
Yes, Judge. The Auditor's Office did raise an issue about whether or not Ms. Storrs could receive the honorarium from the federal government. I recommend that Commissioners Court take no position on that particular situation, since her income or her salary is primarily paid by the state. The county doesn't have any policy that addresses whether or not an employee can receive an honorarium. However, there is a statute that precludes public officials from accepting honorariums. In this particular case, it depends on why that individual was asked to be present and participate in the seminar. In this case, I don't think that it would be appropriate for court to make a determination one way or the other as to whether or not she can receive it. I don't believe that she would be in violation of the statute if she does, and so for that reason, we're recommending that you not make any type of determination as to that.
So your recommendation is that we should not act on it?
Will not act on the issue of the honorarium, and that's not what you're being asked to do today. I think Mr. Ufracio just wanted to make that statement for the record about the honorarium, but as far as making a determination if she can receive it or not, you're not being asked to do that, and I don't recommend you take a position either way.
Well, if that's the case, do we have the authority to move to authorize her to travel?
Yes, you do, and I think that, as Valdes stated, you were being advised, you were just being put on notice that she's...
Oh, but we're not being asked to come up with any money or...
No,
sir.
funding from the
No, sir.
county is being required.
No, sir, it's on the agenda, it's a disclosure that she's going up there, there are no county funds being expended. We're just trying to keep in line with our policy, but we're going to, we've been working with the Auditor's Office, we're going to update the travel policy, and we're going to look at the Ag Extension Service specifically, because the Ag Extension Service agents are not county employees, but we do bring their requests for travel if there's county funds being utilized or county equipment being utilized to court for disclosure purposes.
All right, so we have a motion and a second.
Yes.
And those in favor indicate by saying aye. Aye. Aye, motion carries.
Item D, Judge Commissioners, where I'm asking approval to accept settlement check from Travelers Insurance Company in the amount of $8,080.60, and this will settle a accident with one of our county vehicles.
Move for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And Judge, if I may...
Oscar, what item are you here on, Oscar? I know you wanted to talk about the modular...
7B, that's why I skipped it for a couple seconds, Judge. 7B, which is discussion, consideration, and action, if necessary, including but not limited to, would be the renovations of former administration building first and second, which there's no update today, and update on courthouse portable building project. That's the one that I've asked Oscar to talk about.
Okay, good morning, Judge and Commissioners, and basically, I just wanted to bring the court up to date on the status of the modular project and where we're at right now. Right now, we have pretty much completed phase one of the improvements to the modulars, that being uniting the modulars all in one project and one unit so that we can be able to be functionable for the courts. With that being said, we have a betterment allowance that we now need to address, that we need to go into the modulars and
do some modifications to the modulars for the use of the courts. However, the betterment allowance, or the allowance that we have inclusive in the original PO, was designated for unforeseen situations to the on-site civil, mechanical, electrical, plumbing, everything that the infrastructure that we needed for those modulars to be placed on the premises. So we're going to come before Commissioners Court to ask authorization to use the betterment allowance for the modifications to the courtrooms, so we can be able to address that. We already have that allocation in the PO already. Now, in respect to the initial engagement, I have Mr. Dearman and from Half and Associates and Mr. Magera from Dannenbaum, which I want to thank them publicly for them working with us on this high intense and high profile project to get it done as short in the time manner that is being handled. However, the original conception of the project, we were going to be doing phase one, which was inclusive of the receiving the modulars from Ramtech Building Systems and doing all the infrastructure for them to be ready to be occupied. We have pretty much exhausted all the funding for phase one. And in addition, through the course of the installation of the units, we have now had to adhere to beautification code from the city of Edinburgh, which has prompted additional costs that now we're trying to finish and has been asked to also comply with the beautification code for the rest of the phase, which would be phase two, as outlined on the blueprints of the project. Therefore, we need the authorization, and we just want to bring you up to date as for a discussion so you can be aware of all the project as how it stands. And in the situation that we are, we are ready to do the finish out inside the modulars. All this project, if we, upon a Commissioners Court approval, will take an additional 8 weeks for us to complete the whole entire project and have occupancy by the city of Edinburgh. However, I outlined some details for you for your information so that you can see what the driving forces are behind us being able to complete this project. So we just wanted to bring you up to date, and if you have any questions, well, we have the project engineers here.
All right, initially this project was supposed to have been completed in, what was it, January?
Yes, sir, there was a tentative timeline. Of course, unforeseen situations have...
No, I'm not being critical, I'm just trying to establish a fact.
Yes.
And it was supposed to come in under 2 million.
Well, for the original phase one part of the construction, we had originally engaged into just purchasing the modulars, Judge and
Yes.
Commissioners, so that we could occupy them, but
Based on what you now know, when do you think it'll be ready for use?
if, upon approval of the Commissioners Court, we should have this project done within 8 weeks.
How many?
8 weeks.
8 weeks from today.
Yeah, well, not from today, upon approval of Commissioners Court of the additional funding.
And how much, that's the other question, how much more than the 2 million are we being requested to spend?
Well, the exterior finish beautification code is requiring the rest of the south parking lot. In order for us to continue, we now need to conclude the rest of the parking area for the judges so we can move the judges and secure their safety in the phase one part.
I know we need it, I'm not being
Yes, and
critical,
then-
I just want to
but-
know the figure.
Judge, to
Is
answer your question...
there a final punch list already?
I'm sorry?
Do you have a final punch list already?
I'm sorry, Commissioner.
Do you have a final punch list already?
Yes,
Is
sir.
it-
As a matter of fact, we do. What we need is about, we need 472,542.97 to be exact.
Okay.
And on the exterior finish out.
And you're saying that's being driven by the city beautification code?
Yes, there's about 4 different forces that have been driving this project, and that's ADA, that's city fire marshals, security issues, which includes cameras and many things. And this is just, I guess, a wake-up call, if you will, that we are outdated with our courthouses. We need to upgrade the courthouses. Unfortunately, the growth has come sooner than the projected beautification of the courthouse.
Judge, to answer your question, the overall project, if the spreadsheet is correct that you handed me, Oscar, is
Yes.
$2.2 million.
Yes, we have incurred...
2.2, or
2.2 million.
$2,208,000.
Okay.
Right. And with the additional funding for the exterior improvements, that would bring it to approximately 2.7 turnkey project.
2.7?
Yes, sir.
Okay. And do we have it funded by the?
The additional? No,
Yeah.
the original we had funded, yes, but the additional, that's why it's being brought to court.
So we need action this morning
Yes,
on
if there
that?
is action today, then Sergio and I will get together and we will come up with a funding plan, and then we'll
Okay.
take the appropriate action that needs to be taken. But we cannot, we
Do we
can't...
need action this morning?
Yes,
All right.
yes.
I don't know.
I'm going to make a motion for approval. Obviously, we've got to get it done, but can you report back to the court members where you got that funding from?
Sure.
At least where we're supplementing the funding
Okay,
from.
yes. And Judge...
We have
again-
Second.
a motion and a second. Those in favor indicate by saying aye.
What is the action, Judge? On which item are you taking action on?
Right, I was about to address that, Mr. Ofracio. On the agenda, it always says presentation for discussion, consideration, and action, if
Right.
necessary, and
No,
action.
I read that, but the question is what agenda item?
The action would be item 2, the update on the courthouse portable building project and other ongoing building construction, renovation, repair projects. So the action is updating the need to finish out the project. Now, again,
Well, let me ask, or make a comment. I know it's impossible to project the exact amount that is going to be spent, but when, what I'm saying is about a 30, 15, 20% increase in expenditures. And we're looking at what supposedly was going to be a $2 million cost.
Right.
Or projected cost, now we're looking at 2.7. So, I think we need to take a look at it, not on this project, but any project, especially the next item on the agenda.
Yeah, do some better planning on it.
And to have a construction timetable and do a better job of projecting the cost, because I don't think it's fair to tell the taxpayers we're going to spend X number of dollars on this, and we approve it, and then it turns out to be at this level.
Right. And
so I think we need to do a better job of forecasting.
Yeah, a better planning, we just gotta do better planning on it.
Judge, but I believe that you got to have an agenda item that you're going to act on.
Right.
So my suggestion would be to have an agenda item next week,
Right.
specifics, and also the funding and all of that.
Exactly, that's what I was going to say. Whatever action we take today, that's why I made the comment that I would get with Sergio, and that we would make the appropriate action through Commissioners Court to include what we're talking about today.
But there's no
Well, we
action
were
needed
provided,
today.
Valde, with a list of the scope of work.
Right.
And I believe that's what we were acting on. And also the modification expenses and amounts and how they arrived at this $472,000 figure.
Exactly.
In my mind, that's what we were acting on.
Right. But Mr. Ofracio, I will, to alleviate your concerns, I will have, next week when we work on the funding aspect of it, I'll have proper language to make sure that your office will be okay with respect to invoicing that'll come thereafter.
That's what I'm saying, there's no action needed
Okay.
today. You got direction to go ahead and continue with whatever needed to be done. So next week, you bring that
In
specific
other words,
action.
keep on working. We need to meet that deadline. I mean, we got no choice at this point.
Yes, sir. We're still working on the project, and but if we can at least have action from the court to utilize the 45,000 allowance this way we can proceed to
Oscar, and unfortunately, I know what you're asking, but no, that specifically would have to have been on the agenda. So we're
Okay.
going to have to wait one
We'll bring it
additional
up.
week, but I'll have
We'll
it
bring it up,
turnkey
okay.
next week. But as the judge said, the action in essence is just for us to proceed, do what we need to do, then we'll have the
Provide you
appropriate.
with direction that
Direction
we
and
keep on
appropriate
working.
action for
We'll
next
have
week.
all the appropriate documentation.
And I know that we're, well, I say I know, I had heard that we were behind in payment schedule.
That has been up to par, and as a matter of fact, I want to thank some of the staff of the auditors. They worked with us diligently.
Well,
and
make sure that our
they have
next
been taken
agenda
care of.
item addresses that so that we can make up for
In
it.
addition, I believe that there's some approval for some funding that has also been cleared up, and they'll be going out, I think, in today's action.
Court already approved the check.
Judge,
Yes, sir.
You've got a check.
That particular issue has been resolved.
It's been taken
Okay.
care of.
Has been resolved.
Yes,
All
sir.
right. All right, well, thank you.
Thank you, Oscar.
Thank you.
We'll have something for next week. Judge, Commissioners, that's all I have under my items.
All right, on to item 8, our constables. Precinct 3.
Good morning, Dan Broles on behalf of Constable Gallardo. Under item 37447, Constable Precinct 3, approval to accept local border security program grant award in the amount of $40,000 from Texas DPS Ranger Division for the period of January 1, 2013 to August 31st, 2013.
Move for approval.
And that covers 1, 2, and 3, am I correct?
No, sir. I believe that the other two precincts have already submitted and been approved.
No, 1, 2, and 3 under you.
Under item.
8A1, 8A2,
Yes, sir.
and 8A3.
Yes, sir. To include the certification of funds and the approval to use them.
All right, those in favor indicate by saying aye.
Aye.
Aye, motion carries. Thank you, sir.
I have two more, Judge. Under B, approval of the 2013 appropriation of funds with the U.S. Treasury Equitable Sharing Fund 1257 for the Constable Precinct 3 in the amount of $10,000.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And under C, consideration and approval of 2013 appropriation of funds for the Constable Precinct 3 investigation, House Bill 65, in the amount of $4,621.19.
Move for approval.
Need a second? Second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And item D, Constable Precinct 3 requesting approval to process payment for the following invoice as claims to Mission Quick Lube Incorporated with the authority of the county treasurer to issue payment after review, audit, and processing procedures are completed by the county auditor.
Move for approval.
Those in favor indicate by saying aye. Aye, motion carries.
Thank you, that's all I have.
Thank you, sir. Item 9, Human Resources.
Good morning, Judge, Commissioners. I'm here on behalf of the Purchasing Department to present these items. They're asking to delete 4 positions. I don't know if you want me to read them individually or just take them all up at one time.
Well,
They want to delete a buyer 2 at $39,108, delete an administrative assistant 2 at $31,045, delete a surplus specialist at $31,404, and delete a clerk 2 at $22,303, and then to create the following: inventory specialist 43,289, 284, create a purchase order specialist 3 at $40,078, and create a surplus specialist 2 at $34,360.
is the effect of this to allow individuals to get raises?
Well, they're deleting vacant positions to create
But there's
new
no money
positions.
involved, no extra money involved.
I'm sorry?
No extra money involved.
No.
sir, there's a net savings of $3,000.
I'm sorry?
There's a net savings of $3,000.
But certain individuals will be getting pay raises.
These positions will be advertised, Judge,
Okay.
because
These
they're
are brand
creating
new positions.
new positions.
Okay.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And item 2 is permission to advertise and hire the following positions: inventory specialist 5 at $43,284, Purchase Order Specialist 3 at 40,078, and a Surplus Specialist 2 at 34,360. And the approval of the revised salary schedule.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
B is under the Health and Human Services. They're asking also to delete 3 positions. The Family Planning Aide at 26,014, an Eligibility Specialist 1 at 24,924, and a Clerk 3 at 26,014, to be able to create 2 positions, 3, I'm sorry.
3.
Medical Technician 2 at 26,014, create a Clerk 2 at 24,929, and to create Billing Specialist 3 at 26,014.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. Again, this is not going to allow people to get pay raises.
No, sir, they're deleting vacant
Same amount.
positions and advertising new positions.
Is it going to be one of these like advertisement within where you pick people that already are working there?
It depends on if they're.
Or are you going to open it up to the community?
These, sir, we were looking at this internal for our current positions. Actually, these are more of title changes, sir. These are not actual.
Same amount of money.
We're creating.
But I think that's going to result in individuals getting a pay raise, won't it?
No.
Well, if he
That's what Tony
chooses to
wants.
do it
Same thing.
internally, he will create promotions for his staff,
Right.
individually.
I'm sorry, I didn't hear you.
If he chooses to do the advertising internally, that'll give the employees an opportunity to go for those positions.
Right.
And have a chance for advancement
All right,
within the county.
Go ahead.
Okay, and item 2 and 3, it's requesting permission to advertise those 3 positions
Move for approval.
Check.
and the approval of the revised salary schedule.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item C, also under the Health and Human Services, he's requesting permission to advertise vacant positions. It's a licensed vocational nurse 2 at 44,794, a billing specialist 4 at 32,864, and an eligibility specialist 2 at 28,094, and these are all vacant.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Under D,
Are these positions for grants, Eddie, grant positions, or are they the regular full-time permanent?
These are general funds, sir, but there might be a small component of supplemental, probably less than a couple of thousand, some of these, but they're primarily general fund.
Okay.
And still operating on the, including the statement that you could speak.
On our grant on our grant staff,
Right.
we always ask them to fill out that statement, sir, for all our grant staffs.
Thank you.
Next item, D.
D, I was asked to place this on the agenda by the executive officer for Precinct 3 Commissioner Flores. He wants the approval to delete the following vacant position, which is Administrative Assistant 4 at 42,000. And 2 is approval of a salary adjustment for the following full-time position due to increase in job responsibilities as a result of the elimination of the assistant position.
Why don't you cover all of them so we can act on it?
Okay? Well, those 2 are the ones that I needed to cover. The third one is to create a new position.
Okay, need a motion to
Move
approve
for
1 and
approval.
2?
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And item 3 is approval to create the following position. It's a maintenance 1 at 28,000, and the approval of the revised salary schedule.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Commissioner Tito Palacios, I don't know if you'd like for me to present your item. It's under 19A.
Yeah, go ahead.
It's approval to create a road, let me see, the following position. It's a construction inspector for 40,078. And number 2 is the approval of the interdepartmental transfer and the approval of the revised salary schedule.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
Item 10, our Sheriff's Office.
19.
Yes, sir.
Get the head, buddy.
Judge, Commissioners, Richard Ozuna for the Sheriff's Office, Hidalgo County, on behalf of Guadalupe Lupe Trevino, Sheriff. Item A, if I can take them 1, 2, and 3, is just a swap on personnel. We're just moving one sergeant from the Sheriff's Office to the courthouse, and the courthouse sergeant back to the Sheriff's Office. Order number 1, approval, employee transfer as follows pursuant to 3.49.
Just a minute, officer. Need a second?
Second.
Those in favor indicate by saying aye. Aye. Motion carries. That's the 1, 2, and 3. Go to B.
Under B, just presentation of what I passed out in discussion on the 2012 racial profiling report as presented by the Hidalgo County Sheriff's Office in accordance with Article 2.133 of the Texas Code of Criminal Procedure. If there's any questions.
Need a motion to approve?
So moved. Second.
Those in favor indicate by saying aye. Aye. Motion carries.
Thank you.
Thank you, sir. Item 12, our Health Department.
Judge, item 12A and 12B, there is no action or discussion unless you have questions.
All right, sir. Item C.
Item C, requesting approval of an interlocal cooperative agreement between Texas A&M University and Hidalgo County. The purpose of the agreement is to provide basic disaster life support and advanced disaster life support training, sir. This has been approved by legal counsel as well.
Move for approval.
Those in favor indicate by saying aye. Aye. Motion carries.
Item D, 1 and 2 is approval to process the following invoices as claims with the authority for county treasurer to issue checks after auditing procedures and completed by county auditor. This is in regards to telephone bill. After county changed some procedures on our telephone contract, we've had these procedural claims to have to deal with, sir.
That's D1.
C1 and then D2 is approval to add the following accounts and phone lines to AT&T contractual DIR text TEX-AN-NG-CTSA-005.
Need a motion to approve D1 and 2?
Check.
Those in favor indicate by saying aye. Aye. Motion carries.
Item E, sir, this is also in regards to the telephone policy changes. Approval to process payment of claims for telephone service Verizon Southwest Incorporated vendor 251577 for Wesco Clinic account number as indicated on the agenda in the amount of $158.54, requisition number 00231977 for dates of service February 28, 2013 through March 27, 2013.
Move for approval.
Second.
Those in favor indicate by saying aye. Aye. Motion carries.
Item F, sir, requesting approval of data and use service agreement between University of Pittsburgh of the Commonwealth System of Higher Education and Hidalgo County. The purpose of the agreement is to provide access to relative data for the purpose of public health surveillance, reviewed by legal counsel already, sir, as well.
Second.
Those in favor indicate by saying aye. Aye. Motion carries.
Item G is approval to process the following invoices of claim, which is authority for county treasurer to issue check after auditing procedures are completed by county auditor. This is for Ground Systems Incorporated, and amount is indicated of total amount of $558, sir. This is our satellite link-up system for a communication trailer. And there was a procurement changes as well and procedures that got us to this situation.
Need a motion to approve?
No move.
Check.
Those in favor indicate by saying aye. Aye. Motion carries.
Item H, requesting approval to continue participation with the Texas Infertility Prevention Project for an additional year. The TIP state project is to promote the prevention of STD-related infertility in women, and this is a project we have with the Department of State Health Services.
Need a motion to approve?
Second.
Those in favor indicate by saying aye. Aye. Motion carries.
Item I, so requesting approval of public health emergency preparedness grant contract number 201304120400A. The purpose of this amendment is to revise the general provision to include potential need for utilization of up to 5% for public health emergencies and/or training. The effective date of this amendment is March 20th, 2013. This is to allow our other grants to participate in case of an emergency event, sir.
Move for approval.
Check.
Those in favor indicate by saying aye. Aye. Motion carries.
Item J, 1 and 2, we've already been discussed, sir. Thank you.
Thank you, sir. Item 13, Urban County.
Good morning, Judge Commissioners.
Morning.
Our first item on the agenda is a request on behalf of the City of Mercedes requesting the authority to purchase one computer workstation for the library. The purchase will be made through the county's membership and participation with the State of Texas Buy Board. The amount of the contract or purchase will be $5,044, and it'll be funded through the 2012 Mercedes line item.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B is also a request on behalf of the City of Mercedes requesting the authority to purchase 3 computers for the Mercedes Library from Dell, contract number DIRS DD 890TX. Also an approved vendor through the Hidalgo County's membership and participation.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item C is requesting exemption from competitive bidding requirements under Texas Local Government Code 262.024.
Move for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Section B is presentation of the scoring grid for the purposes of ranking by Commissioners Court. This is 3 architectural firms. The 3 firms evaluated are Mata Garcia Architects LLP with a grade of 96, GMS Architects with a grade of 93.67, and Naismith Engineering with a grade of 88.67.
Move for approval.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Section B is the authority to negotiate an architectural service contract with the number 1 ranked firm of Mata and Garcia Architects.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item D is requesting the authority to enter into a 36-month lease through Hidalgo County membership with state-awarded vendor RICO Corporation through contract DRSSD 1674 for 2 digital copier printers.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item E is requesting the appointment of 1 board of director to the Hidalgo-Willacy Housing Finance Corporation to replace former Commissioner Joel Quintanilla. The traditionally,
The commissioner is involved, right? I mean,
I'm sorry?
could we replace him with Commissioner Glad?
Yes, sir. Normally, the Hidalgo-Willacy Housing Finance Corporation has 3 members from the Hidalgo County and 2 members from Willacy County. It has always been the tradition for the County of Hidalgo to appoint existing or sitting commissioners.
Commissioner?
Recommend.
Yeah,
Second.
all right, Commissioner A.C. Cuellar to be appointed to the Hidalgo-Willacy Housing Finance Corporation. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Our next item is requesting that the court rescind the action taken on 122-13, which approved the interlocal cooperation agreement and project between Hidalgo County and the Hidalgo County Irrigation District Number 6, which called for the provision of 21 irrigation crossings for Precinct 3 street improvements.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 2 is the acceptance and approval of a revised interlocal cooperation agreement between the county and Irrigation District Number 6 for those 21 irrigation crossings, and the amount shall remain the same at $46,305.
Move for approval.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 3 is acceptance and approval of the revised interlocal cooperation agreement.
Move for approval.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
That's all I have. Thank you.
Thank you, ma'am. Item 14, elections.
Good morning, Judge. Good morning, Commissioners. I don't have, item 14A, I don't have an additional appointment yet, but I am handing out a memorandum just so that you are aware that I spoke to Lubbock County this morning, and they are down to between 2 days for the workshop that we had talked about, either Wednesday, April 17th, or Thursday, April 18th. They are planning on bringing 2 commissioners as well as 3 or 4 members of their staff. They take this very, very seriously. And so this court had decided that we would hold a workshop. So I would like for you to look at your calendars, and we will be calling your offices just to make sure that we have a good court representation, since they are planning to bring their commissioners as well as various staff members. I'm also coordinating, and I already did work with Mr. Villarreal, and thank you to Commissioner Joe Flores that has graciously allowed us to use the Brayfogle Pavilion, where we will hold our first vote center committee meeting. And the second page, of course, is, I've already given you that list. But Lubbock County says that they will come early enough to meet that evening and then come the next day to court for the workshop, so we could coordinate both workshops, as you can say, a meeting and then a workshop together. So please be aware of these dates, and as I said, I will be calling your offices to make sure that they are set in your calendars. Any questions?
Thank you, ma'am.
Yes, sir.
There's no action on 14A?
No.
We'd already acted on these members.
Yes, sir.
Yes.
Yes, sir. Just giving you an update.
All right, item 15, WIC.
Good morning, Judge, Commissioners. We're here to, my first agenda item is the approval of the amended WIC contract. We got it in. It's for 2013-0425-9901-001A between Hidalgo County Health and Human Services WIC program and the Department of State Health Services, DSHS, to extend the contract period through September 30th, 2013.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And then we're asking for authorization for the county judge to sign the amended contract.
Move for approval.
Those in favor indicate by saying aye. Aye. Aye, motion carries. Thank you.
Thank you.
Item 16, right-of-way.
Judge, Commissioners, Mr. Peña is not with us today. I think the court is well aware of...
Yes.
Okay, so for right-of-way department, there's consideration approval of to grant AEP Texas Central Company utilize existing easement to install additional facilities to serve a new Head Start building. And this will be located at 1208 Paula Street, Palmview, Texas, as well as the authorization for the county judge to execute the AEP Texas Central Company letter, and that's dated February 19th of this year, evidencing an approval of the same.
All right, need a motion to approve?
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you, Judge, Commissioners.
You're welcome, thank you.
Yes, sir.
Item 17, our planning department.
Good morning, Judge, Commissioners. Raul Steen, Planning Administrator. First item is just requesting approval for the County Treasurer to issue a check in the amount of $96 for the recording fees for the Hidalgo County Precinct Number 1 Constable Office Subdivision.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And item 2, on behalf of the Arbery County Program, we're requesting the consideration and approval of the following: authorizing the submission of an identification of colonial request to the Texas Water Development Board to ensure the inclusion of Salazar subdivision within 2012-2013 Colonial Economically Distressed Area Program fund application, the amount of $500,000, designated Salazar subdivision as an officially identified colonia, in which the subdivision will be provided an M number and be included with the list of Hidalgo County identified colonias. And item number 2, and authorizing the county judge to sign any and all documents associated with the county's submission of the identification of colonial request to the Water Development Board. This is one of the colonias located in the northeast corner of Cesar Chavez and 495. Is currently, the city of Alamo had applied to provide sanitary sewer. It's my understanding that they're trying to designate this as a colonia so they could be eligible for yard line services once the sewer is in place by the city. So it should improve the colonia and get it off the septic tank scenario and get it into collection system.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you very much.
So that was just 1 and 2.
One and two.
All right, item 18, precinct 1.
Judge, Commissioners, we have the authorization for the appointment to the Emergency Service District Number 1. This covers the Westlaco area, and the appointee will be...
James A. Voss.
James A. Voss.
What's that last name?
Voss, V-O-S-S.
All right, need a motion to approve that nomination? And a second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And we also need authorization for the appointment to the MHMR Board. And
Joe
that's,
Rodriguez.
Joe Rodriguez.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
Is there a vacancy in that one?
That's a
The one- Okay.
It's a reappointment.
It's a reappointment?
Yes.
All right, thank you, sir.
I was informed that I have a precinct 2, that's another.
Oh, Precinct 2 has a vacant appointment. You want to nominate somebody?
Well, it's not on the agenda, but I'll have it probably next week.
Okay.
Number 20.
We got A and B out of the way.
Right, you're the one that's needed, Tito. Okay, Precinct 3, item 20, Mr. Varela.
Well,
Item 20, Precinct 3.
Good morning, Judge.
Morning, sir.
Good morning, Commissioners. Requesting approval to process the following invoices as claimed with authority for County Treasurer to issue payment after reviewing, audit, and processing procedures are completed by County Auditor.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Judge, item 21A.
Thank you, Judge.
Is
Thank you,
dis-
sir.
Discussion, consideration, and approval for executed notarized warranty deed in favor of Hidalgo County, Texas, transferring ownership of 2.50 acres of land for the purpose of providing a site for erection of a multi-purpose facility to be used for emergency services. As you know, just to give you a little history, Judge, this is the county, we're obviously beneficiaries of a land donation by the Flores family. We have every intent to work with the community on building a building that we are going to establish a presence there by providing some of our equipment to be stored on site, equipment, materials. We are also looking at engaging for public services of fire protection and other services. But this is the beginning. We do got a land donation. We want to accept the land donation by...
And this is by the Flores family?
Yes, Judge. Now, I know there's a concern by the auditor, and I understand his concern. In the warranty deed, there's some language in there stating about the naming of the building. We didn't have a condition or an intent when we first talked to the Flores family. It's obviously the wishes of the family that we consider the husband to carry the name on the facility. We have every intent to bring it back to court at this point in time. We just want to accept the land and obviously bring an item on the agenda for the court to consider when we get further along on the development of a multi-purpose site.
So, Steve, have you had a chance to review the deed and are the conditions okay?
I have not reviewed the deed.
I know Josie has.
Our office did, Judge, Commissioners. At the outset, the Flores family had submitted a previous gift deed to the county that the Commissioner asked Mr. Rene Guerra to review, and I believe he spoke with Commissioner in the precinct and advised them that we recommended against accepting the original gift deed because of the language, the reversionary interest. As per Mr. Guerra's direction, our office did meet with the Flores family and their counsel, and they revised some of the language in this gift deed, and this is the new one that you have before you. Again, it's up to you, Judge and Commissioners, to accept the gift deed, but we did work with them to revise some of the restrictions on the transfer of property. You're not precluded from accepting it in this fashion.
You're talking about the new location or the former?
This is a new site.
But the property?
Yeah, it's a very good piece of property. It's located on, what is it, 186?
It's on FM 186.
Corner?
The road going from the expressway, 1017 intersection to Raymondville.
Yeah.
Now, it's complete, it's adjacent to the property that the state has where we have a MOU with the state. So we're using both properties. One will store some site materials on the state land.
Is that where the little park was?
Yes, sir.
Yeah. Second.
Steve, in the past, you had opined that it is not a good idea to accept a donation with a condition.
Is it a condition or reversionary clause?
Well, one of the conditions that they name the building in the name of someone. And
If the county accepts that deed with that condition, they're bound to name the building by that name.
It's a reversionary.
What's wrong with the?
No, well, in the past, Steve had opined that it is not a good idea to accept an asset or a donation with a condition. They had to be without any condition. So that's what I'm just asking.
It's better to not have any conditions.
Okay, but it is, okay.
All right, we have a motion and a second. Those in favor indicate by saying aye. Aye. Aye, motion carries. Item 22.
Morning, Judge Commissioner Sergio Cruz, Department of Budget and Management. Item 22A, we'll be requesting no action on that item. Now, on item 22B, discussion of courthouse financing, we'll also defer the discussion to the purchasing item that we have later on the agenda. So we'll no action on that one. We'll have the discussion during the purchasing item. Item 22C1 is approval of 2013 appropriation of funds in the amount of $76,870.55, and these are for special vehicle inventory operating expenses.
Move for approval.
Check.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Item 22C2 is approval of 2013 appropriation of funds for the county clerk's record archive in the amount of $599,500, and these are for restoration and preservation of Hidalgo County Clerk historical records. Requesting approval.
Second.
What item are you at?
Item 22C2.
22 what?
22C2.
All right, those in favor indicate by saying aye. Aye. Aye, motion carries.
Item 22C3 is approval of 2013 appropriation of funds for the Precinct 1 Road Maintenance Program, 005, in the amount of $60,000, and these are also for operating expenditures.
Move for approval.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Thank you.
Wait a minute, what happened to 22B?
22B, I was going to defer the discussion to the purchasing item that we have on the agenda. We have a purchasing item regarding the schematic design.
Oh,
So-
wanted with another item?
We can have the discussion at that point.
All right.
Good morning, Martha Salazar for the Purchasing Department. There is nothing to discuss or report to be given on item 23A12, A, B, and C inclusively. We go to item 3, which is presentation of tabulations for Commissioners Court award to multiple vendors for pipes, reinforced polyethylene, corrugated PVC, storm sewer pipes, etc., as mentioned on the title on the agenda. Those 3 vendors would be, if I just wrote them here, sorry. Contech, Ferguson, and HD Waterworks. We need action.
So move.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item is we are requesting no action on item 4. The next item we have coming up will be approval to rescind action taken by Commissioners Court on March the 5th, 2013, agenda item 36874A for the acceptance and approval to award to the best value proposals to Facilities USA for the concrete work and water line improvements to Constable Precinct 1 building. And this is because the JOC no longer has the award for, and that was before the proposal was submitted, so we can't accept it. They are not awarded through the JOC program.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B would be authority to review, consider, and negotiate with the second JOC proposal received for that project, Herrera and Hunt, for possible acceptance and action or award by Commissioners Court.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Since you've taken action on B, we'll have no action on C. Item 6. This is the nomination from Hidalgo County's approved pool of architectural services providers for the nomination of 3 firms as required by the county's protocol for the schematic design phase of a new Hidalgo County courthouse facility. Now, I know there was some concern voiced before. This phase has never been engaged or has been paid for. There may be some confusion.
I'm sorry, can you get closer to that microphone?
There may be some confusion because the court did engage a firm to create, develop, and present a master plan.
Correct, and they've done that.
And that has been done. Now, this phase would be the schematic design. I have included in your agenda as backup the definition of the schematic design phase. I've also included the actual pool of architects. Now, there had also been some action late in 2012 to engage an architectural firm for the entire courthouse complex. That would be all phases of the design and construction. However, at that point, I think that our funding was the issue at that point, so that did not proceed, even though there had been a committee appointed. We also had a change of administration, plus the pool expired in February of this year. So this is now being proposed on a phased basis for the schematic design phase. You do have, as your backup, the different firms. I don't know if you all are prepared to nominate three or nominate all the local firms as you had done with a previous action, which of course did not get completed, which was for a courthouse facility.
Marty, so is the funding in place for this particular project?
This funding is not in place because we're just nominating, and we're going to, at the point of a selection or ranking, yes, you'll have to have some.
I thought second was going to discuss the financing of the facility at this point.
Okay, yes, Mr. Cruz is available for the discussion on that part.
Currently, there is no funding appropriated for this project, for the courthouse project. However, I was going to recommend to the court that we do have funding within various COs that have not been expended, which we could utilize for this project, and that's what I would be recommending for the court if they're going to go into the schematic design. One thing, however, is the schematic design would probably be completed within, I would say, 4 months. So we would have to have a backup plan as far as what we're going to do for when we go into design development, which would be a more costlier phase of this project for the county. So at that point, we would either have to consider either issuing bonds to finish out the rest of the architectural services for this project, or utilize, again, to scrap some additional projects that we have within our current certificates of obligation and use those fundings for this courthouse design. But again, right now, we don't have any earmarked funds for the courthouse. We would have to use from existing projects that we would have to delay from current projects.
All right, let's talk about the item. We need to nominate
At least three
firms.
Yes, let me get into my backup for this item so that, I don't know if each one of you has a copy. Oh, I'm sorry, Ms. Chapa would like to.
Before we go into that, I just want to also say to Commissioners Court that one of the reasons that we decided to move forward with this is the City of Edinburgh has been waiting, and they have communicated with us that they're willing to join in this effort with us, but they need to know that we have ongoing before they can promise or they can commit a certain amount of money to help us
For
with
the
it.
benefit of the public, the city's willing to participate in the cost of the schematic design and also in the cost of the construction up to approximately, they've indicated 20 million, whatever the cost may be. I know, Ms. Townsend, do you want to address the court at this time? I know you indicated earlier you wanted to in this issue.
I believe Marty explained where I may have thought it had already been done. But what I worry about and what frustrates me very much when we go into projects, especially large ones, is we kind of piecemeal it because we have to, we don't have the money. But then we've got this over here and that over there and somebody else in charge over there. bottom line, when we get everything together and we go forward on this, I want either one firm or one person to be in charge. Somebody has got to answer. Somebody's got to keep track of as it goes, why it falls behind, why it's not in budget. I mean, somebody has to answer to you all. And we never do that. It just kind of, we float along and hope it goes well. I don't want to do that with this. So my frustration is, okay, we've got this done and we're getting this done and maybe, I just want it all to work together. A little frustrated. Thanks.
All right, we've been provided with a list of 16 different architectural firms that are part of our pool. Do you have a list? Do you have any extra lists?
I'm trying to force myself to use technology, so all I have is my iPad, to less paper.
Well, I've got a hard copy, but I've only got one, and we're spreading it around. So it may take a little while then.
You can have one of them. It's item 6. We've got one more iPad that someone can use to review.
Oh, I got one. It's on my background.
Okay. Is there anybody else who needs?
What's that?
I got it.
All right, it's been suggested by Commissioner Palacios he would nominate architectural firm of Alcocer Garcia and Associates, number 1, and number 4, ERO Architects, and number 14, Janak and Associates. And I would, let me ask the rest of the court.
I'll second that.
All right, do you have any other additions, Commissioner?
Yes, it can be more than 3.
I'd like to include Dannenbaum Engineering in there,
What number are they?
Some of the projects that we've had as
That
well.
would be number 7.
Number 7?
Dannenbaum.
Okay.
And then I have no problem with the other selections.
No, I was, as long as it included ERO, they did all the work initially on the master plan. Okay, we've got those 4
All right,
firms
that's Alcocer
designated.
Garcia and Associates, ERO, Janak, and Dannenbaum.
Yes, I need a motion to accept those 4.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries. Now we need to select our evaluation committee.
Yes, sir.
Marty, did you say earlier that it was permissible to select ERO even though they did the master plan? You mentioned it earlier?
Yes, sir, we discussed it back when we were going to try to go with an architect to do the whole thing. But I don't believe there's anything that precludes them from, they're
Why
not
would
going to
they not
duplicate
get it?
any work.
Well, because they developed the master plan, and the only issue would be that they have an advantage over the other
Well, it
folks.
seems
If anything, I think it makes them more
knowledgeable about the
Well,
project.
or more attractive to nominate. That doesn't make them the sure, the sure firm, but it certainly, it's only because it's open knowledge that they are. But remember, the selection is based on the submitted statements of qualifications, not on what we may just know. It's obvious because everybody knows they did the master plan, but it's on the submitted statements of qualifications.
Yeah, and that's the issue, that in their qualifications, they're going to indicate that they were responsible for developing the master plan for that particular project.
But they were, I mean, it's,
So, the other ones were not.
no,
All
but it's
right.
based on it.
And the item is selection and assignment of an evaluation committee
Yes,
to
Judge.
score and grade the firms.
How do I get back to
Silguero, Precinct 2.
here? Agenda, here. Pardon me?
Why don't we just say that it'll be the 5 members of the court or their designees?
Well, I do want to caution the court that if there are any members of the court, I would recommend the designees because you may be subject to Open Meetings Act when you start grading.
There's a new Attorney General's opinion that came out this year
Right.
that states that.
Okay, then the designee, I would designate Yolanda Chapa.
Raul Lozano.
Okay?
Marcos Lopez, Precinct 4.
And call Commissioner Flores and
Bingo.
And let us know who Commissioner Flores wants to be his designee to select the architect to build a courthouse.
Commissioner Tito, you nominated
Raul
Silguero,
Silguero.
correct? All right.
I need a motion to approve those designees.
Motion.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries. The only one missing is precinct 3.
Correct, and I will call them on that. Item C, I would believe then there's no action because it was the option to go out on a project-specific RFQ.
All right. Is this where we're going to talk about that item we passed over?
Yes, sir. Again, on that item, again, we would have to, currently, since we do not have any funds available for this project, we would have to go back and look at existing projects and defer one of those projects for a future year and move this project up for this year.
And can I make a suggestion?
Yes, sir.
There are some monies, and I don't know if it's received by the treasurer at this point in time yet. It was some general CO funds that were used for the purchase of some land for the city of Edinburgh, of which the city of Edinburgh is in the process of cutting the check and sending it to the treasurer. I mentioned to the court, it was a general, it was a countywide fund that we used, and that should supplement the needs for this phase. I made that suggestion to the judge and the other commissioners, and there is funds. I just don't know if they're received or, again, utilizing that opportunity to.
We need to be serious about this and start designating certain funds and set them aside for the purposes of constructing this courthouse. That's a very good suggestion. It's there, and we ought to be able to set that aside. It's unreserved.
We can reserve that. Once we receive the funds, we can bring that back to court to reserve for the courthouse construction fund.
Now, if you see some more immediate funds that are already on hand, it's just a suggestion to the court that there is funding, and I think it'd be appropriate for us to secure it for this phase.
Include the city of Edinburgh, 20 million that the judge made reference to.
Well, they already got.
Well, no, they came in and told us that they would be willing to get. Right. Right. And there's also, we've looked at it and talked to Sergio earlier, or to Balde, and there's 150,000 from that project that we almost got involved in here at the school here at Edinburgh on McIntyre.
Yeah.
And there's also, as I understand it, the district clerk, there's a fund that has grown up to the amount of 1.2 million approximately. Look into setting that aside. Why don't you start looking, and then we can talk about the issues involving all these monies. Clear them up and then just designate them for a courthouse building fund.
We'll do that. We'll bring those items back.
The particular amount of money has not been transferred yet. I know we discussed that, and the monies are still in the district clerk's account.
Identified, and then we do.
Yes, then we'll talk about how we can get it, if we need it, how we can get it done.
What needs to be done?
I think you need to get direction from the court, I would think.
Right.
I already had sent her a letter and instructed her to transfer it. It has not been transferred yet.
Ahorita typical saying is identify potential.
No, and I agree with Commissioner Palacios. We should identify all funding. I know there are other needs that we need to address and other projects that we're looking at doing, and some projects are moving, some projects are not, but I think from a comprehensive nature, in a workshop form, or at least convey to all the commissioners what the options are.
I'll make a listing of all the pending projects and the funds available for those projects and bring them back to court, all submitted to the court prior to the meeting date. That way the court can look at those projects, see which ones can be deferred, and maybe the funds can be reallocated to the courthouse fund.
I think there are other funds available. I've been in discussions with budget office. There's funds available in other areas that they could tap into.
And you can suggest any, don't feel bashful. I mean, look at the budget, look at the funds that we have that out there that are available and see what you can recommend.
Yes, sir.
All right.
Before-
Anything else?
Yes, before we go on, I believe Commissioner Flores has announced through...
Oh, yes, he nominated Mr. Mingo Villarreal.
Correct.
Domingo? Who? Domingo.
Mingo. Joe Flores nominated Mingo.
Ya hablaron con él.
Sí.
Judge,
Yeah, he called him in.
I believe we're going to have to go back to a motion to include Mingo.
To include Mingo.
Domingo Villarreal.
Mr. Domingo, I need a motion and a
So
second
moved.
to add him to our committee.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
On item B1, Precinct 2, this is pursuant to Government Code 262031 and the interest of expediting project's progress. We're asking, Precinct 2 is asking that the precinct commissioner be permitted to sign change orders in $50,000 or less with no more than an increase of 25% or no less than an increase of 18%, and that requires the contractor's approval. There was a concern that the designee was not named, and at this point, I believe the designee by Commissioner Palacios would be Raul Silguero. Am I incorrect, Commissioner? Is that correct? Yes.
All right, we have a motion and a second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item is Precinct 3. This is requesting exemption from competitive bidding requirements under the Texas Local Government Code, Section 262-024A4, a professional service. May I have the exemption
approve.
first?
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
This is presentation of the scoring grid for the purposes of ranking, those being Hinojosa Engineering at 99, Gutierrez Engineering at 94, and Quintanilla, Headley and Associates at 93. Does the court wish to rank them in the order of those scores?
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And then we'll go to the authorization for purchasing to commence the negotiations with number
Move for
one.
approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And for the record, this is for Benita's landfill project. We're going to go on to item D4. This is Precinct 4. This is requesting exemption again from competitive bidding requirements under 262.
Marty, I think you skipped
Marty,
number
did you
two.
do C2?
Oh, I'm sorry. I skipped it. C2, acceptance of sole bid received and approval of order confirming sale document for request for bids for the sale of real property at Precinct 3.
So moved.
Who's the sole bidder, Marty?
The old precinct offices.
No, who is the
Who is the
sole
bidder?
bidder?
Oh, let me get that for you. I think it was Dr., she was on our Civil Service Commission, Dr. Sonia.
Who is it?
I'll give it to you in just a minute. I'm going to my backup. Here we go. Dr. Sonia Trevino.
Sonia Trevino?
Trevino, yes.
And what was the bid?
The bid was what was asked for as the minimum bid, plus she realizes there may be additional legal costs, which was 100 and something thousand.
Okay.
It was track 182,955.
All right, any other questions? Okay, then go ahead.
We need a vote on that motion.
That's all we had.
I've got
Let me
no-
get a motion to accept the sole bid.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Now going on to D, Precinct 4, 1 is the exemption under 262-024A4, a professional service.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
No, Marty, on that particular item, the funding that was identified was certificates of obligation funding for the project.
Yes, and I think Commissioner was going to address that
Yeah,
issue.
yesterday I submitted a letter to bond counsel. I had an opportunity to meet with Ms. Chuy Ramirez this morning. I supplied a letter to the auditor, and it pretty much specifies what our intent is for the use of the construction of this building as a multi-purpose facility. In respect to the auditor, I'm willing to sit down with the auditor and legal counsel to assure that all i's are dotted, t's are crossed. The intent of the building is to be used for public use. The county's going to retain ownership of the building. We have every intent to use existing staff to be on site, store equipment of the precinct, materials of the precinct. At the same time, look at engaging with other nonprofit entities within the area, such as the Lynn Samoa Fire Department as potential tenants alongside with us, utilizing proper interlocal agreements. I know that Chewy did render an opinion that it can be done, so as long as for public use, and he is prepared to submit in writing his analysis on our summary of the intent of the construction of the site.
That's correct, Commissioner. He has confirmed that we can use certificates of obligation series 2010 A and B for this project, and he will be delivering a written confirmation, a written opinion within the coming days.
Judge, Commissioners, I do want to state for the record, we're dire beneficiaries here in this project. It's rare that we ever get land, well, we get land donated from time to time, but in this case, we do have other entities giving us monies for the construction of this site. For the record, the Hidalgo County Emergency District is contributing $250,000. The Lynn Samoa Improvement Corporation is donating, pledging, and giving us $75,000. The Emergency District was $250,000. The value of the land donation is $46,000. And currently, we still don't have in writing at this point in time the Lynn Samoa Volunteer Fire Department, their fundraising. And in this, we have several entities coming together for the betterment of the community to contribute funds for the development of this building, which is going to be, in fact, the owner, or the owner is going to be the Hidalgo County. We want to take advantage of, obviously, the kind contributions of these different entities and develop something that's direly needed. In other counties, fire protection is a fiduciary duty of county government, and the benefits are with having a group like the Lynn Samoa Volunteer Fire Department to provide that service there. They do not have a home right now. Unfortunately, they lost their fire department about a year or more ago, about a year and a half ago, and we're just trying to be catalysts in the development of such a facility to be able to help assure that the services that are needed in that area are given.
So, I guess whenever those entities are going to give you the funding, you'll come back and
yes,
with the interlocal and also acceptance of the donation?
Yes, sir. Well, we do have letters at this point in time. They are submitting their contributions. We will work with your office as well as legal or anybody that we need to assure that it's done proper.
Well, I consider myself a member of the Lynn San Manuel community, and I know I speak for the community when we want to join in thanking Commissioner Palacios for his role and leadership in bringing this project to fruition. It's a badly needed project, and I'm glad to see it finally happening.
Thank you, Judge.
All right.
I need
Go ahead.
the exemption, please.
Motion.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Now I'm presenting you the grid for the purposes of ranking of the pool of professional architectural services providers for the Lynn San Manuel Emergency Services Project located in Precinct 4. That would be Negrete and Associates with 96, Naismith Engineering Company at 95, and Mata and Garcia Architects at 98. Does the court wish to rank them in the order of their scores?
So for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Then the third item is for purchasing to be given authority to negotiate an architectural services contract with the number one ranked, Mata Garcia.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item, 2, is requesting approval for payment of invoice number 11846 for DeBose in interest, DBA Performance Grade Asphalt, PO number 682505, dated October 16, 2012, for $6,550.40 for the purchase of emulsified MS1.
Move for approval.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
The next one is requesting approval of the final negotiated professional services contract agreement that was authorized on January 15th with Half and Associates for the building repairs, renovations, alterations, or additions to county-owned buildings on an as-needed basis.
Move for approval.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
Item 3B is to accept the final the final professional appraisal services agreement with Leonel Garza Jr. and Associates, and that's for the purpose of any fair market value appraisals, et cetera, as presented on the agenda, as authorized on January 15th.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next one, E1, this is approval to purchase one new or newer 2013 Dodge 1500 Quad through the county's membership and participation with HGAC Houston Galveston awarded vendor Dallas Dodge Chrysler Jeep with the contract as shown in the amount of $41,817.36, which includes the fees that are applicable. There is a concern from the auditor. What has happened, what is going on is that we usually ask the vendor to provide us the verification of pricing. In this case, this is a new vendor. We received verification of the pricing through through a staff member with the title of, I think it's Procurement Services Specialist from HGAC. The lady noted in my response to the concern says that she is verifying that the pricing is correct. However, we are going to be calling the vendor. It'll be subject to them submitting what we usually get, and I'm going to stress this, as a courtesy from other, like Philpott Motors and Caldwell Chevrolet. They, under the buy board, are not obligated to give us their pricing, but they do because they know the requests that we get and the auditing procedures in place. So I ask the court to approve it subject to receiving that, and I will not issue the purchase order until that is received.
Need a motion to that effect?
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next one is for Health and Human Services, F1, acceptance of sole bid received and approval of contract for the request for bids of additional laboratory services for Hidalgo County's Health and Human Services Department. And let me get you the name of that.
So bid. There's no questions. Entertain a motion to approve.
So moved.
Second.
And the name for the record is Quest Diagnostics.
What was that?
Quest Diagnostics.
Okay.
That's
Those
the sole
in
bid.
favor indicate by saying aye.
Aye.
Aye, motion carries.
And our last item is approval and action to reject bids received for Hidalgo County welding supplies and other miscellaneous items as bidding vendors did not meet specs, and with authority to re-advertise.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. This time pursuant to 551-071 and 072. Need a motion to proceed to executive session.
Move for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries. It's 11:57. We'll be in executive session for a while.
So you run out of time.
Chris. We're convening with an open session. Mr. Guerra?
Thank you, Judge, Commissioners. Under open session, Judge, Commissioners, item A, 25A, real estate acquisition appropriation, same, no action. Item B, pending or potential, no action. Item C, no action. Farsamon Alamo Independent School District and South Texas College et al. Versus Reynaldo Ortiz. Item D will be brought for next week, potential litigation, electric service provider. Item E, claim of Feliciano Ramos, no action at this time. And item F, claim of Alfredo Villanueva, there's no action at this time.
So no action on any of those?
For the next meeting, can you invite, or at one of our subsequent meetings, invite Andy Taylor to come and report to us?
Yes, that's actually what, that's the purpose of me placing this item on for next week so that I can have the proper documentation before I get Andy to come down, Judge. But it should be in the next couple of weeks. We can ask him to come down.
If no action is needed, then entertain a motion to adjourn.
So move.
Those in favor indicate by saying aye. Aye. Motion carries. Thank you, gentlemen.
Ya son dos por la Teresa.